Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, February 26th, 2025. We have 9 bills on the docket, and we're going to start off with Senate Bill 825 with Senator McCray. Come on up. Nina, welcome.
Thank you. Good afternoon, Mr. Chair, members of the committee. Nina Themelis, Director of Government Relations for Mayor Scott in Baltimore City, here to testify in support of Senate Bill 825. This bill is a reintroduction of a bill from 2023. It would add 3 types of enforcement officers to the list of those who receive extra protections under state law. So currently, we have our police officers, firefighters, EMS workers, other rescue workers who, when assaulted, the individual who commits the assault can be charged with felony secondary assault. The 3 types of officers, parking enforcement officers, traffic enforcement officers, and special enforcement officers, are appointed by our police commissioner to offload the responsibilities or some of the responsibilities of our police department so that our police can focus on only the most serious of our public safety issues in the city. But in taking on those public safety roles and duties, they are not able to be armed and they are not able to make arrests, but they are put in vulnerable positions across our city. A few examples of these incidents are our traffic enforcement officers work alongside our sworn police officers for large-scale events, so Ravens games, events at CFG Arena, Orioles games where there are tens of thousands of individuals entering and exiting the facility, and assaults do sometimes happen. We just, from the city's perspective, don't think that it's fair that if a police officer is assaulted in this instance, that there would be one type of charge for the victim for the assailant, but for a special enforcement officer, this traffic enforcement officer, that charge would not be the same. We do have a few people signed up to testify today. We have a couple of our animal control officers as well as a few of our traffic enforcement officers, so you'll hear testimony from them directly, but we just request and urge a favorable report for Senate Bill 825.
Thank you, Mr. Chair. What was the bill number from 2023?
Oh, let me see. Have it.
Or you can just get it to me afterwards.
Yep, it is. It's right here. Senate Bill 764.
Thank you.
Yep.
Thank you, Mr. Chair.
Further questions from the committee? All right, seeing none. Thank you very much.
Thank you.
All right. We'll now hear from Aaron Howard, David Chadwick, and the rest of the witnesses will be joining us virtually.
Good afternoon, Chair and Committee. Again, my name is Aaron Howard. I'm an Animal Enforcement Officer Supervisor with Baltimore City Animal Control. I'm here today, I stand before you with 10 years of experience with Baltimore City Animal Control, asking for you to support Senate Bill 825. I believe it's very important. Myself and my coworkers regularly are put in positions where we are placed in combative situations, and we have been typically and regularly and more often throughout the years assaulted. Guns, knives have been pulled on us. We've been spat on. We've had animals attempted to attack us. Most recently, while executing a warrant, we removed animals from a property. 2 individuals followed us to our facility. One was armed with a firearm and threatened mass violence against us. Another individual then pointed me out directly, stated he was going to find out where I live, where my family lives, and cause harm to me. Though this bill may not be preemptively be able to stop them, I can say it gives us reassurance as sworn commission officers in Baltimore City that our elected officials are taking our safety serious, and that's why we ask for this bill to be passed. Thank you.
Good afternoon, Mr. Chair and the committee. My name is David Chadwick. I am an Animal Enforcement Officer for Baltimore City Animal Control, the Health Department. I would like to ask you to support the Bill 825. Throughout my 11 years, I experienced violent encounters, assaults, threats, and to do physical harm to me. Also, off-duty, animals that I have removed from properties, the owners have recognized me out in the public, has threatened me. My most recent encounter, me and my coworker, was removing dogs for humane concerns. The dog owner ran out, started yelling profanity. I tried to explain to him, calm him down. Then he pulled a gun out on me. He started yelling for me and a coworker to move out the yard. Then he started yelling racist comments to my coworker. As we removed ourselves from the scene, he threw all our equipment out in the alley. Once we clear, we let the authorities know, and they came and arrested him. Another moment was another dog owner had pulled my coworker by her hair, dragged her down to the ground. I intervened and tried to escalate the whole situation. We are always tasked to help vulnerable animals in situations, to get them out, and get them help. And our jobs is very dangerous. We are not armed, and we have nothing else to protect us besides ourselves. With this bill support, this help us reassure that, we still have something to look for as we do our job, and also have to charge people that assault us. Thank you very much.
Excellent. Thank you both very much. We're going to hear from the panelists joining us virtually, and then we'll open up for questions from the committee. So if Maurice Robinson you're up next. Welcome, sir. I think you're still on mute. Hold on 1 second there. Excellent.
Good afternoon, Chairman and lawmakers. The reason why I think this bill should be passed, SOB 8025, because myself was assaulted before, and I believe that if this bill was passed or this was paused through the legislation, the people would do right by us by not having to object us to ridicule and certain prosecution that we had to face. When I was assaulted, the people did just randomly assaulted me. They didn't think they cared I was an officer or not. They just knew that we as agents, we don't have many rights, so they can do what they want to us. I think that by passing this bill, it will give us protection. Also, it will also give us some type of reassurance that when we do our job, we don't have to worry about people not facing criminal charges against them.
Excellent. Thank you very much, Mr. Robinson. We'll now move on to Tamiko Event.
Good afternoon, Chair and the committee. I am Sergeant Tamiko Avent with Department of Transportation Enforcement. I have over 24 years of service with the City of Baltimore. Thanks for giving me this opportunity to speak with you. It has been particularly hard for the past few years with cowardly citizens targeting the transportation enforcement officers that are trying to serve the residents and visitors. What is not understood is that we are safety officers, and some of the disrespect I've noticed is a little unbelievable. We would like to have a safe environment to effectively do our jobs without any incidents that is happening at this point. On several occasions, officers have been pushed, spit on, liquid thrown on them, even a gun pulled out on an officer. We have officers out on accident leave at this time because they were struck by a vehicle because a citizen refused to obey the directive that was given by the officer. An officer was punched in the nose, so therefore her nose was broken. It is very unfortunate that when it is reported that it is literally nothing that the law enforcement officers can do. They generally suggest that we just take it to court. We have been instructed to increase our productivity ticket count. So this will increase the number of times that we must go in undesirable areas where we are more than likely to encounter the same people with destructive acts over and over again. We live in a city where a lot of people are so defensive and always feel disrespected.
Excellent. Thank you very much. We have one more witness joining us virtually, and that's Ms. Stacy Mills. Welcome.
Welcome. Good morning. Good afternoon. I think this bill should pass so we can have reassurance of definitely safety is first. And I'm also a victim of a hit and run where I have a long-term disability. I suffer PTSD doing traffic. I've been threatened with a gun. And then this 24/7 shifts that they're trying to come up with, there's no safety put in place for us. And just like Sergeant Yvette said that, we have to go in these certain areas these times of night. Like we need some type of safety out here because we're getting assaulted. So I feel like this is why this bill should, pass. Just so we can reassure safety is first.
Excellent. Thank you very much. Excellent. Thank you very much. Thank you for joining us. Thank you, Ms. Mills. We'll now open it up to the committee for questions. All right, seeing I just want to thank you all for everything you do to keep us safe, and thank you for your time today. Thank you very much. All right, you all have a good one. Excellent. All right, thank you, Ms. Themelis. So with that, that'll conclude the hearing for Senate Bill 825. We'll now move on to Senator Hester, who's joined us with Senate Bill 905. Senator Hester, welcome.
Thank you, Mr. Chair, members of the esteemed JPR Committee. It's great to be back again. This is the last time you're going to see me this year. For the record, Senator Katie Fry Hester, Senate Bill, and I'm testifying in support of Senate Bill 905, criminal law, identity fraud, artificial intelligence, and deep fake representations. This legislation is essential in strengthening Maryland's ability to combat identity fraud by addressing the evolving threats posed by artificial intelligence and deep fake technology. As you've heard me say before, the rapid advancement of AI technology has made it easier than ever to create highly realistic synthetic media, including altered images, videos, and audio recordings. Now, while these tools do have legitimate applications, they also present serious risk when misused for fraud, harassment, and deception. The malicious use of AI-generated content to impersonate individuals threatens personal privacy, financial security, and public trust in digital systems. The consequences of this misuse include financial harm, criminal activity, emotional and psychological distress, erosion of trust, and exploitation and manipulation. Colleagues, other states have already taken action in this way. Last year, New Jersey introduced bipartisan legislation extending identity theft laws to include fraudulent impersonation through AI and deepfake technology. Maryland must take similar steps to protect its residents from this growing threat. Ultimately, presenting a false representation of someone utilizing AI is a form of identity theft. Senate Bill 905 ensures that Marylanders are safeguarded against AI-driven identity fraud by, first of all, expanding the definitions, updating the legal definition of personally identifying information to include biometric and digital signatures, incorporating legal definitions for AI, deepfake technology, and false impersonation records. Second, it provides civil restitution and victim support, empowering courts to order civil damages for victims, including reimbursement for clearing credit histories and resolving fraudulent debts. Third, it prohibits the misuse of personal information. It criminalizes the unauthorized acquisition, use, or sale of personal information for fraudulent purposes. It also prohibits the creation and distribution of deepfake or synthetic media that impersonate individuals without consent and causes harm. Fourth, it strengthens the penalties. It establishes penalties based on the value of the benefits obtained from the crime or harm caused to the victim, and it imposes stricter consequences for violations involving multiple victims, election interference, or harm to minors. Finally, it enhances enforcement, granting law enforcement broader authority to investigate and prosecute identity fraud cases across jurisdictions, and establishing clear guidelines for interagency coordination and reporting to ensure effective enforcement. Maryland must act now to address the dangers posed by AI-driven identity fraud, and this bill provides the necessary legal tools to combat these emerging threats and to safeguard our communities. I thank you for your consideration and urge a favorable report on Senate Bill 905. And I have a few folks here to help me, Sarah David, John Cox, and Ben Yellen. Sorry. You're done. Okay. Go ahead.
Afternoon, Chairman, members of Judicial Proceedings. I'm John Cox, Deputy State's Attorney for Baltimore County. Also speaking on behalf of the Maryland State's Attorneys Association in support of Senate Bill 905. I happen to be the assigned prosecutor in a case that's pending right now that's gained a lot of notoriety, at least in the Baltimore area. A circumstance where a high school principal, a recording of that high school principal's voice spread like wildfire over the internet. And within that voice were very anti-Semitic and racist comments. It caused quite a response. It obviously had a great effect on that principal. He was removed from his position temporarily. He eventually got back into a position when he realized it wasn't actually him. But if you ever listened to that and if you ever knew that individual, you would be absolutely convinced that that was that person. That was created by artificial intelligence. This bill will address and help us in the efforts that we made to try to find a crime for what happened in that particular circumstance. We were stuck with the ironic, fortunate piece that this happened in a school. So we're able to charge the individual with disrupting a school activity by putting that out there. It happened very fortunately, and again, tragically, that there was also in a peripheral investigation, we were able to find an allegation of a theft. We left and we're still with and trying to pursue this as a stalking. But it left us in a circumstance where the outrageous nature of what happened here is not fairly addressed in the laws of the state of Maryland right now. This bill will address that in both creating the definition of harm by stealing a person's identity. Identity theft right now primarily addresses theft, and you can't place a value on the emotional distress that's placed on a particular individual. This will address it and create that definition of harm and put us in a circumstance where very serious activities can be appropriately addressed. Thank you.
Good afternoon, Mr. Chairman and members of the Judicial Proceedings Committee. My name is Brittany Dunklow, and I am a Senior Assistant State Prosecutor for Election Law at the Maryland Office of the State Prosecutor. Our office handles political corruption, police misconduct, and election law cases throughout the state. While the full scope of artificial intelligence has yet to be realized, the anticipated dangers need to have real consequences. That is why we are requesting a favorable report on Senate Bill 905. The legislation before this committee is drafted to truly criminalize the identity theft component. It alters Maryland's existing identity theft statute to include the use of artificial intelligence and deepfake technology, using the theory that artificial intelligence is indistinguishable from an identifiable human being, and that it is created with the intent to be indistinguishable. It is not satire or a cartoon or meant to entertain. By adding the language to the identity theft statute, it makes it clear that it is not criminalizing the fact that the material is artificial, but criminalizing the intent to make people believe that it is authentic. These cases are extremely difficult to prosecute under our current laws, and as advancements in technology make artificial intelligence more available and more capable, our laws must also adapt. We would like to thank Senator Hester for her leadership and guidance on this bill and encourage a favorable report. Thank you.
Good afternoon, Mr. Chairman and members of the committee. My name is Ben Yellen. I am the Program Director for Public Policy and External Affairs at the University of Maryland Center for Health and Homeland Security. We set out last spring to address the Pikesville problem, as Mr. Cox mentioned. The infamous case, we worked with Senator Hester and Senator Hedelman on a potential legislative solution. Our first pass at that came, some of you will recall, several weeks ago with Senate Bill 362, which would have imposed criminal penalties on the distribution of forged digital likenesses. Members of this committee asked some important questions about that bill and raised very legitimate concerns. First, that the bill might be broad enough to criminalize even de minimis alterations of photo, audio, or video. And second, that legally cognizable harm to any individual was not a prerequisite under that piece of legislation. Senate Bill 905 would solve the problems identified in the Pikesville incident in a way that's narrower and I think more likely to pass constitutional muster. A tool like Senate Bill 905 in the toolbox of a prosecutor, especially considering the significant penalty therein, would provide a proper disincentive for the type of crime we saw perpetrated at Pikesville High School. This approach would also ensure that de minimis changes to audio and video, or those that wouldn't cause legally cognizable harm to any person, are legally protected. And I'm happy to answer any of the committee's questions.
Good afternoon, Mr. Chairman and members of the Judicial Proceedings Committee. My name is Sarah David, and I'm the Deputy State Prosecutor at the Maryland Office of the State Prosecutor, asking for a favorable report on Senate Bill 905. We want to thank Senator Hester for her leadership on this important issue and on this bill, because it is the future of ensuring accountability in so many aspects of our legal system. My colleagues are here bringing cases. One of my incredible able colleagues, Joyce King from Frederick, is unable to be here because she's in court, but there was a very difficult case out of Frederick involving young people's images being circulated around the high school engaged in sexual activity that also sort of fell under this challenge. And so this legislation is the collaborative effort of several jurisdictions to come together and face the varying AI challenges and deepfake technology put in our cases. So this is an effort to be on the forefront of those challenges, and looking at several models throughout the country, thought the identity theft statute made the most sense, because this is actually the intent to take over somebody's identity, right? To purport to be that person. As Ms. Dunklo alluded to, it's not a meme, it's not a joke, it's actually the effort to take over somebody's identity. And that intent matters, right? Just like my intent in obtaining your address for a wedding invitation is not criminal, but my intent to obtain your address to receive benefits certainly would be. Another important aspect of this legislation that I want to highlight that Senator Hester alluded to is the injunctive relief. This is on page 7 of the legislation, and it allows a victim not only to have civil damages, but to come to a judge to stop the distribution of the image. Oftentimes what we see is these are difficult investigations. They involve a lot of extractions of phones, computers, et cetera. What the victims ultimately want is the distribution to stop, and that is part of this. And so, we urge a favorable report on this legislation and welcome any questions.
All right, thank you all very much. We're going to have a couple questions. I saw Senator McKay first, then we'll go on to Senator West.
Thank you, Mr. Chair. This question is for the sponsor. Sponsor, thank you for Senator for bringing this important bill. I think it's important that we fix the issue. In the committee testimony, the Motion Picture Association has some language. Are you aware of that, of the additional language?
They shared it with me earlier today.
Okay. It just talks about, are you in favor of that, or you would not like to have that language added to the bill?
I'd honestly like a chance to read it over, but as was said earlier, I mean, this is supposed to be, intent to impersonate, and I would almost say that, when you go to see a movie, you expect it to be fake. So I don't really think it's relevant, but I haven't read it in detail yet.
Okay. Well,
I mean, I trust this committee. This committee has a lot of bills before it in this area, and I think you really are the lawyers who understand this the best. And so I trust the committee to, adapt the bill as they see fit.
And I'm willing to have the discussion later, but it does seem an amendment that would make this work and address some of their concerns. But we can talk offline.
Sure, of course.
So thank you.
You're welcome.
Mr. Chair, and why don't I address my questions to Ms. David? And I want to do that because your parents are very good friends of mine.
And I've been being punished for being their child for so many years, I suppose. It does.
Every Hopkins student
they've told me
that's
that you
taken
come
that
down
class has been-
they've told me you'd come down to appear before my committee. And I figured I'd wait till the next time you got here and I would ask you a question. So here it is. And it really relates to the question Senator McKay asked a few minutes ago. There is a bit of a tension between this bill and the First Amendment. Wouldn't you agree? That if we go too far, we're traipsing on First Amendment rights. But if we keep ourselves within confines, we don't traipse on First Amendment rights. So, and I'm looking at the proposed amendment, which you probably had not had a chance to see.
I have not.
But wouldn't you agree that we need to be careful in passing this bill to avoid interfering with First Amendment rights?
So I would say we need to be careful to avoid encroaching on First Amendment rights, but that's not going to be an issue with the bill as it's written here. It would be an as-applied challenge to the bill, right? So the bill on its face doesn't implicate the First Amendment because of the way that it's drafted, with the intent element to actually be to impersonate. That said, I think, Senator, you're absolutely right that there would be as-applied challenges to the bill if the bill were to be used to criminalize something like satire, and we deal with that all the time. And as Ms. Dunkel, we deal with that in election law. We deal with that in a lot of spaces where people say, as applied to me, this is a First Amendment challenge. But on its face, I don't think it presents that challenge.
But then there's the issue of chilling one's free expression of views. So I think what you're saying is that if there were a case brought in the court case, the person who is alleged to have violated this bill, this law, if we pass it, could raise as a defense that there was no intent to do what this bill says is impermissible. But isn't it possible that if we're not careful in writing this bill, people will refrain from expressing views in using AI in ways they otherwise might, out of a concern that they might be hauled into court?
Absolutely, and that's why we approached this bill in sort of our initial discussions with that in mind, understanding that sort of by putting it in the identity theft statute again, we sort of don't deal with it as being just merely the creation of the image using AI, but because it's an identity theft, the nature of the crime itself is the implication of I'm trying to make people think I am you. And so that makes it sort of steer away from some of the First Amendment issues that come up with sort of general AI application. And so I think that we've handled it pretty well, like on its face as it relates to a First Amendment challenge. And those as-applied challenges, I think we'll just have to deal with as they come up. But you're absolutely right. That's something that somebody would say, my intent was not to make people actually think I was the president telling people not to vote. I thought it was funny. And then we have to navigate that, as applied.
Thanks very much for your answers. And the next time I have dinner with your parents, which will probably be pretty soon, I will tell them we had a delightful exchange of views. Thanks.
Thank you. I'll tell them the same.
All right, further questions? I won't say what grade certain someone got from your father as a professor at Hopkins, but we'll pass on that one. All right. Potentially. All right. Further questions for the committee? All right. Thank you all very much. Thank you.
Thank you.
All right. All right. Can we hear from? We'll hear from Karen Morgan. I know that we had a representative from the Baltimore County State's Attorney's Office, but Mr. Schellenberger signed up, but I assume.
He won't be here.
Okay, excellent. Okay, and.
Okay.
Joyce King is not going to be here. Oh. And the next person, then we'll switch over to our favorable with amendments panel. Welcome.
Okay, thank you so much, Mr. Chairman, members of the Judicial Proceedings Committee. My name is Karen Morgan. We really appreciate being here today to testify in favor of Senate Bill 905, and we thank Senator Hester for sponsoring this legislation. I do a lot of presentations on fraud prevention all over the state. And one of the first questions I run into is, what about the grandparent scam? And is AI going to affect my ability to protect my grandchild if AI is being used in a grandparent scam? And we're dealing with this question all the time. We haven't even gotten to deep fakes yet. And so this is a real concern. And what troubles us about the proliferation of AI and deep fakes is that these criminals spend apparently 24/7 figuring out ways to weaponize our humanity against us. It is in our DNA to believe what our eyes are seeing and to listen to what our ears are hearing. And they have found a loophole around that and made it possible to line their pockets with our money by taking our humanity and saying, you can't believe what you see anymore. You can't believe what you hear anymore. We, at ARP, the national office last year, did deep fraud intensive training, for all of us fraud volunteers across the country. One of the things that we did was we talked about AI, and one of the staff members offered to be a guinea pig. And within 30 seconds, that person was placed in a jail cell, and there was text about how this person was charged with a crime. And it looked totally real. None of this happened, but it took 30 seconds. So because of that, we think this crime needs to be a felony. It needs to be vigorously prosecuted, and we ask for the committee to issue a favorable report. Thank you.
Forgive my ignorance, but what is the grandparents scam?
Oh, okay. I will be happy to answer that for you, Senator. The grandparent scam, and this actually happened to my mother, who was a grandparent. You get a call in the middle of the night or at some time saying, your grandchild has been arrested, your grandchild was in a car accident, and you need to send money right away to make sure that that person doesn't get in trouble or doesn't get carted off to jail. This is what happened with my mom. She got a call about her grandson. And of course, as a grandparent, you want to rescue your grandchild. That's just human. And so she went and cashed some gift cards. She bought some gift cards and delivered them to the criminals. And then she was in the process of doing that some more. Of course, she didn't call her daughter the lawyer. That would be me. She didn't mention any of this to me. But she did get around to calling my brother, only to find that her grandson was perfectly fine. But they got a few $100s from her. Fortunately, it wasn't more. But all these scams can happen in all kinds of situations with a spouse, with a child, with some other relative. And with deep fakes, you can actually create video of this person being carted off in handcuffs under police escort. And none of it's true. So that's what the grandparent scam is.
Thank you for the education. Thank you, Mr. Chairman.
Further questions from the committee? All right, thank you very much. It's a pleasure seeing you. All right, next we'll hear from Margaret Durkin, who signed up favorable with amendments. Is Margaret here? All right, with that, I believe we have reached the end of the witness list, and the end of the hearing for Senate Bill 905. Senator Hesser, thank you very much. That'll conclude the hearing for Senate Bill 905. We'll now move on to Senator Carrozza with Senate Bill 933.
Good afternoon, Mr. Chair and members of the distinguished Judicial Proceedings Committee. For the record, my name is Mary Beth Carrozza, Senator representing Maryland's coast, Worcester, Wycomico, and Somerset counties. And I really appreciate having the opportunity to present Senate Bill 933 to you today, which would prohibit a person from knowingly and willfully causing another to ingest without their consent an abortion-inducing drug through fraud, coercion, force, or the threat of force when the person knows or believes that the other person is pregnant. This legislation recognizes non-consensual or forced ingestion of an abortion-inducing drug is a crime with penalties. I want to thank Senators West and McKay for co-sponsoring. I want to be clear that this legislation does not restrict a woman from having an abortion. Senate Bill 933 is narrowly tailored to specifically address an issue on the rise, and that is the non-consensual ingestion of abortion-inducing drugs. I use the following cases from other states, as Maryland is one of only 3 states that does not compile abortion data or pregnancy care data. May 2013, Remy Lee, a Florida woman who dreamed of becoming a mother, was tricked into an abortion by her boyfriend, John Andrew Weldon, who gave her Cytotec, a brand of misoprostol, telling her it was an antibiotic for infection. Lee was rushed to the hospital after taking only 1 pill, and she miscarried her baby at 6 weeks. When doctors inspected the pills, it was discovered they were not antibiotics, but abortion pills. Weldon was indicted under the rarely used federal Unborn Victims of Violence Act, a murder charge that carries a life sentence. February 2014, a woman in Brooklyn, New York was rushed to a local hospital when she felt intense pain in her abdomen. The doctor removed 2 pills that had been inserted transvaginally without her consent during sexual intercourse by her boyfriend, Siobhan Remy. The doctor identified the pills as the abortion drug Cytotec. Several hours later, she miscarried at 14 weeks. Remy, the father of the child, was charged criminally with forced abortion, a felony punishable by up to 4 years in prison under New York law. May 2017, Brooke Frist from Arlington, Virginia, was 17 weeks pregnant when her boyfriend, Skinder Imran, a doctor, slipped a drug into her tea, knowing it would likely cause her to miscarry their son. Brooke went into premature labor hours later. She was rushed to the hospital, but her baby boy did not survive. Imran lost his medical license, pleaded guilty to fetal homicide, and was sentenced to 20 years in prison, but only served 3 years. March 2022, Catherine Herring is a Texas woman whose former husband, Mason Herring, grounded up the drug misoprostol and poisoned her water with it in order to force an abortion without her knowledge or consent. Fortunately, Catherine realized what was happening when she found an empty package of the misoprostol in the trash, and she sought medical intervention in time to save the life of her daughter. Mason Herring was charged initially with felony assault to induce abortion and accepted a plea agreement on charges of injury to a child and assault of a pregnant person. Due to the poisoning, Catherine's daughter was born prematurely, requires a feeding tube, and will need lifelong medical assistance. May of 2024, a woman in Massachusetts lost her baby when her boyfriend, Robert Kawanda, went through an online pharmacy to obtain misoprostol. Prosecutors say he orchestrated a call from a fake nurse to advise the victim that she should take iron pills due to her blood levels. Kawanda then showed up at the victim's home with the supposed iron supplements and even checked her mouth to ensure that she had consumed the drugs. The woman miscarried the next day. Robert Kawanda was criminally charged with attempted poisoning, assault and battery with a dangerous weapon on a pregnant person, and assault and battery on a household or family member. Some of you in this committee may remember Senate Bill 561 of 2019, known as Laura and Reed's Law. Laura Whalen from Albany, Maryland, was 4 months pregnant when she was killed in September of 2017, and her boyfriend was charged with the crime. She was killed because he knew she was pregnant. He died in his jail cell before the trial began. Laura was killed by her boyfriend because she was pregnant, and she had planned to keep the pregnancy. She had given her future child the name Reed. Laura and Reed's law makes a crime of violence against a woman that the perpetrator knows or believes is pregnant an additional felony with a jail sentence of up to 10 years, in addition to any other sentence imposed for the underlying crime. The reason I am bringing attention to Senate Bill 561, Laura and Reed's law, is to highlight that this legislation today, Senate Bill 933 of 2025, serves a similar purpose. Forcing a woman to ingest abortion-inducing drugs because she is pregnant is an act of domestic violence. In 2019, we learned that nationally 1 in 10 pregnant women will experience physical abuse at the hands of an intimate partner, and pregnancy-associated homicide in Maryland is 10 times the national average. In Maryland, 10 times the national average. In 2023, the Maryland Network Against Domestic Violence reported 38 fatalities due to domestic violence. Over 1 in 3 women, 35.6%, and 1 in 4 men, 28.5%, in the United States have experienced some form of domestic violence in their lifetime. Abusive people believe they have the right to control and restrict their partner's lives. Forcing a woman to end her pregnancy through fraud, coercion, force, or the threat of force is a form of domestic violence that eliminates her bodily autonomy and her choice. I want to share additional statistics that supports the timing of moving ahead with this legislation now. The number of yearly abortions in the United States rose by 10% between 2020 and 2023, and the most common form is abortion-inducing drugs at 63%. Again, this is the most common form, abortion-inducing drugs. This does not include abortions that take place within the home. In Maryland, you can have abortion pills mailed to you if you meet certain requirements, such as having a Maryland address. And while there is no specific information about the number of miscarriages in Maryland, again, because Maryland does not compile this information, roughly 15 to 20% of pregnancies in the United States end in miscarriage, making it the most common complication. If someone is motivated to force a woman to ingest abortion-induced drugs without her consent, they would have the means and the opportunity in Maryland, and they also would have an alibi by claiming the abortion was just a miscarriage. Now imagine that you wanted and planned to bring the pregnancy to term, but you thought your own body failed you, resulting in a miscarriage. Imagine the emotional pain and heartbreak you would feel only to learn that someone took advantage of your trust and poisoned you, ignoring your choice, your bodily autonomy, and your personhood. Mr. Chair, one of the reasons that I'm bringing the bill at this point is that it's common knowledge and factual that access to abortion has been expanded in Maryland, especially through telehealth. We can expect the number of abortions to increase statewide, along with it an increase in the forced ingestion of an abortion-inducing drug. We should be concerned that 44% of abortions nationally are performed on African American women, despite only accounting for 13% of the female population. As a state with a prominent African American population, we can assume that the Maryland percentage would be much higher. I would like to address some of the testimony that was favorable with amendments and the opposition testimony. I agree that Senate Bill 933 should be amended that upon conviction of the crime of non-consensual ingestion of an abortion-inducing drug, that the person is subject to imprisonment not exceeding 10 years, as opposed to the 25 years as originally introduced. I also want to address the opponent's claim that this new crime and penalty is not necessary. The recent deregulation of chemical abortion drugs by the Food and Drug Administration has set up a new crime of opportunity. Until very recently, there was remediation standards that required that a woman receive a doctor's examination before getting prescribed chemical abortion pills. Teleabortion changed that, and now women and others can get these potentially lethal drugs online without ever seeing a doctor. This creates a perfect opportunity for fraud and coercion. So a new crime calls for new penalties. Also, there is no legitimate argument that this will be used against women. The way Senate Bill 933 is written, this is a complaint-driven, meaning that the woman herself would have to file charges against a person under this new crime. This committee hears bills on a regular basis that creates a specific crime. In this case, a new crime is justified and even necessary due to recent FDA deregulation and increased online sales of abortion drugs. Also, again, in the opposition testimony, this bill does not go after providers of abortion. It goes after the abusers, the perpetrators of domestic violence. In summary, Senate Bill 933 prohibits a person from knowingly and willfully causing another to ingest an abortion-inducing drug when that person knows or believes that the other person is pregnant and without consent, through fraud or coercion, or through force or threat of force. A person who violates someone in this manner would be subject to a felony charge and face penalties, which could include no more than 10 years of imprisonment. I look forward to working with this committee on this necessary legislation to protect women from being victims of this crime of non-consensual ingestion of abortion-inducing drugs. I really thank you for your kind attention. I'm sorry that the other members were not here to hear some of this testimony, and I request that the committee work with us on a favorable report on Senate Bill 933. I'd like to present my panel of witnesses. If they could go forth before questions, Mr. Chair. And we'll start with them.
Good afternoon, Senators. I'm Deborah Briccato. I'm a retired registered nurse and also a former volunteer of over 8 years at a pregnancy resource center. I'm happy to say that I am very much in strong support of Senate Bill 933. As a volunteer at a pregnancy resource center on the Baltimore City, Baltimore County line, I saw many clients from the city, so many of them were young Black women. While they were at the center for support of a current pregnancy, many of these young women had told stories of forced abortion of a prior pregnancy. After that, they experienced depression and even suicidal ideation for the loss of their child. These women need to know there is a legal recourse against this type of domestic violence and violation of their bodily autonomy. Senate Bill 933 will not interfere with a woman's ability to make the decisions about whether to prevent, continue, or end a pregnancy. Senate Bill 933 seeks to prohibit another person from taking away this woman's choice to continue her pregnancy. My concern is for those women and girls who coerced into ending a pregnancy they wish to continue through force, threat of force, or unknowingly ingesting abortion-inducing drugs. The abuser is putting the lives of both the baby and the mother in jeopardy. The two drugs used for chemical abortion are mifepristone and misoprostol. Misoprostol can also be used alone to cause abortion. Used alone, misoprostol is taken in several doses, dissolved in the mouth or in the vagina. Again, misoprostol causes contractions to bring on the abortion, and bleeding can continue for several weeks. The FDA recommends use of misoprostol and mifepristone only through 10 weeks of pregnancy. Risk for failure of complete abortion and adverse events increase with greater gestational age. Those risks include hemorrhage and infection. Hemorrhage can lead to respiratory compromise, heart attack, and death. Infection can lead to sepsis and death. Because of the use of telehealth to get these prescriptions, and because misoprostol can be used to treat gastrointestinal ulcers, men are able to obtain this drug and they can use it against a woman. They can crush it up and put it in her food, or as you can see in the other stories. So I urge you to see this bill as common sense legislation to protect women and help them to seek justice for domestic violence, and please support and give a favorable report on Senate Bill 933.
Excellent. Thank you.
Thank you, Chairman and committee members. I'm here today to urge a favorable vote for the Women's Freedom from Coercion Act. In 2019, Remy in Florida was 6 weeks pregnant when she trusted her boyfriend, who said he was giving her medicine. You've heard other stories today from the witnesses from women who were all over the state. And this has happened consecutively from 2017, 2019, and 2023. And all the stories you'll hear today are just a brief snapshot of the violence against women that happens all the time because someone else wants control over their bodies by any means necessary. As a women's advocate in the spaces of human rights and anti-exploitation for over a decade, and a volunteer in my community for survivors of abuse and unplanned pregnancies, I, Patrina Mosley, can tell you for a fact that pregnancy increases a woman's risk for violence or worse. In 2020, the risk of homicide was 35% higher for pregnant women compared to those other women who were not pregnant. In previous years, it was just 16%. And of course, the homicide rates were highest amongst adolescents and Black women. At the same time that these risks for homicide and violence increase for women, unfettered access to abortion-inducing drugs have increased, with one survey finding at least 72 websites selling chemical substances to terminate pregnancies. A New York Times investigative piece showed just how easy it was for him to purchase these drugs. Times are changing, and with this new accessibility, it can and it has empowered abusers to have complete control over a woman's pregnancy decision. This also includes women who are being trafficked, whose bodily autonomy has already been taken from them and now they are re-traumatized. When abusers knowingly and willingly poison pregnant women with the intent to take away their choice, this is violence against women and it must be stopped. I urge a favorable vote to support women against violence in this modern day and age. Thank you.
Chairman and members of the committee, my name is Jonathan Alexander. I serve as legislative counsel for the Maryland Family Institute in support of the Women's Free from Coercion Act. As this bill addresses a growing crisis, it is the abuse and coercion of women through the non-consensual administration of abortion-inducing drugs, forcing women to take the abortion pill. There are real-life cases all across the country that show the demonstrated urgent need for this law. In Texas, in this past year, a husband repeatedly laced his wife's drink with abortion drugs, caused severe cramping, and led to the premature birth, which injured their child. Virginia, right next door, in 2018, a doctor secretly spiked his girlfriend's tea, ending her pregnancy at 17 weeks. In Florida, 2014, a man forged a prescription, tricked his pregnant girlfriend into taking the abortion pill. And in Washington State, a nurse practitioner, after an assault and a rape, forced abortion drugs into the woman's body without her knowledge, which resulted in the loss of her pregnancy. You know, these aren't hypothetical situations. These are horrifying realities that demand action. And without this bill, these predators are now armed with the proliferation of abortion drugs. They can exploit telemedicine and mail-order abortion to commit violence against women. SB 933 provides justice for these victims. It makes this felony punishable up to 25 years, or as the amendment states, 10 years. And this bill can get Maryland closer to where we need to be, punishing predators and giving a recourse to victims. It's about protecting women and ensuring that no one is forced or deceived into ending a pregnancy against their will. For these reasons, I urge you to stand against coercion, to stand against abuse, and vote in favor of SB 933.
Excellent. Thank you all very much. Questions from the committee? Senator James.
Thank you, Mr. Chairman. Thank you. I appreciate the bill sponsor talking to me earlier. And as we discussed, and I realize you won't have it today, but I think in your testimony you had 4 or 5 instances of this, something like this occurring around the country. And my question to you had been, well, what kind of laws were in place when these prosecutions occurred? Were they criminal laws like the one you're proposing, or did they prosecute the cases under existing laws? So hopefully.
So there were several cases that I referenced, but also Mr. Alexander mentioned cases as well. What I'd like to do as a follow-up is to not only share those cases, but point to the laws, especially those states that have, similar laws on forced abortion.
Right.
So we will follow up with that.
I don't even know if there's an analogous situation, but, and then just to make our lives easier, I do not know what the laws are in Maryland that may be applicable or may be spot on and, directly helpful to any situation like this where there's fraud, coercion, intimidation, and what other incidents. So, and I actually was looking through the file to see if I could find, Attorney General or anybody's help. Maybe they filed it, but so it's really not incumbent on you to do this, but if you wanted to, you could also perhaps provide me with what laws there are and tell me why they're inadequate. They may be. I don't know because I don't even know what the laws are in Maryland for circumstances like that. I don't know what someone would be charged under currently.
Right. And I think, again, in my testimony, I focused on we have new circumstances.
Right.
New circumstances with, what's happened with FDA, new circumstances with the increased use of the abortion-inducing drugs that is creating these additional opportunities.
Right.
So that's why we were looking for, a specific crime and to be associated with certain penalties.
Right, but I will tell you, there are cases where people are poisoning their partners, telling them they're giving them one substance, but it's another. Arsenic and Old Lace is a movie about it, but that's, we don't want to inject too much humor, but, there's two little old ladies that, ended up poisoning all kinds of people. They were dear ladies, but they were awful too, right? So, I mean, we do have history of people doing things
if I
analogous
could,
but not identical, but cause harm. I mean, some of them
agree.
cause death, and I think, that might be the ultimate harm. And I don't know, but I imagine we have laws that cover very similar circumstances, but I'm not confident of that, so you could get back to me.
Well, and I'd like Mr. Alexander, who is an attorney, to underscore why we are zoning in on a specific crime and why the current laws are not adequate.
Thank you.
With permission, Chair, just to answer that question. So many of the cases that we mentioned do have federal laws that are attached to them, or it is a crime to harm the child. Because in the situation you mentioned as well, where there are poisons or other things given to individuals, that potentially can be covered under current Maryland assault and battery claims. You can bring that forward. But there is a unique aspect to the abortion-inducing drug where the law is limited because of the harm that occurs to women to only assault or battery and never speaks to the actual child. So the harm that she receives as well is potentially the injury or death to the child. Maryland only recognizes fetal homicide at 24 weeks, where the baby is considered viable. And so without addressing the person that is in the womb, other areas of the law, federal law can do that. Maryland is limited because if the child hasn't reached that 24-week period, they aren't considered viable. And so a claim made in order to protect the life of the child isn't brought forward. So
I think since biblical times, though, it's been illegal, immoral, obviously, but illegal. And I think under current law that, harm to an unborn, whether you call it a child or a fetus, it is a crime.
Yeah, it is. But once again,
I don't know what has to be homicide. And certainly homicides usually don't have a penalty of only 10 years. So I think, I see your point, but I do think that there are lots of laws that deal with this already that criminalize the harm to a pregnant mother and the harm to an unborn baby or fetus.
And this is a particular harm to mother. The proliferation of the drug as a result of the FDA lowering the regulations and allowing it to be mass-produced, sold, telemedicine without any interaction with, obviously, a doctor. There's no way for any individual to determine the gestational age of the child. That has created a particular harm for pregnant women. and that isn't covered by other areas of law.
Well, that may be, and that's an interesting topic, but and that would require us to take a look at, telemedicine standards and our own very intense healthcare system rules and regulations and the like, right? Yes. So one other thing, just real quick. Do you know in the cases you mentioned how the defendant who's successfully procured the
yeah, in certain instances, one was a doctor that forged a prescription.
Well, yeah, that, for putting
another
aside
was
that
a
one,
nurse.
that's forgery by a doctor.
One just lied, and telemedicine at times, even to meet with certain privacy standards, you don't have to have a face-to-face, even over the internet, as it were, and so you can procure through false signatures or other false pretenses an easily accessible pill. And the mass proliferation, particularly in this state where we stockpiled at the end of 2022, mifepristone and mifepristol for the purposes of reacting to the Dobbs decision, it should become more and more prevalent as we're reducing the requirements for nurses to prescribe them or the doctors to prescribe them. So a bigger problem targeted towards pregnant women. It gives more and more weapons to the hand of an abuser or a predator, and they're now armed with this particular pill to further abuse women.
Women are very, very vulnerable to a lot of things. I don't know about this, but I will say to you that you bring up, not necessarily limited to this bill, the issue of, and to what extent, medicines of any type are more readily, wrongfully procured through modern telemedicine or distant medicine, and I don't know the answer. I don't even know if we're keeping track of it, but that's just a good issue to think about. So I appreciate your answer.
Yeah, we're here standing for the vulnerable women that have been victims of this particular crime.
Thank you. Thank you, Mr. Chairman.
Further questions from the committee? All right, Senator Croza, thank you very much. Okay, our next we'll hear from is Pamela Palumbo here. And then we have one person joining us virtually. That is Brooke Myrick. Welcome. Brooke, can you hear us?
Yes, I can hear you.
Excellent. The floor is yours.
Hi, my name is Brooke Myrick, and I'm a healthcare team manager for Heartbeat International. Through our affiliate centers who every day assist women making pregnancy choices, we often hear of abortion decisions that were not made by the pregnant woman herself, but rather made by others against her will. An abuser is able to force an abortion on a woman with a pill that is readily accessible or added to her food or drink without her knowing. In addition, as a nurse overseeing the abortion pill rescue hotline, we receive calls frequently from women who have started a chemical abortion under coercion or force. Women have called our hotline who have been assaulted as abortion pills are physically forced into their mouths. Others have been poisoned by a person they trusted who secretly added abortion pills to their smoothie, their oatmeal, or their dessert. Some have been locked in rooms or closets and only freed once they relented and took the abortion pills against their own wishes. Once these women are in a safe place, they are so desperate to continue their pregnancies, they call our hotline for immediate assistance. This underscores that, in these instances, the abortion decision was never the woman's free choice, but rather a decision made by another. One woman who called our hotline just last Sunday said her husband gave her no choice but to swallow the first pill. After he left her, she desperately searched for assistance and found our hotline. Within 1 hour, she was connected with a physician who provided medical care to save the life of her child, as well as urgent resources to ensure her safety. As the abortion pill becomes more readily available, provided through telehealth, and through more than 70 websites, such cases are now commonplace. We support this bill, which provides criminal penalties for anyone who forces a pregnant. Thank you for your time.
No, excellent. Thank you very much. Questions from the committee? All right, Ms. Myrick, thank you very much. Thank you for hanging in there with us. All right, with that, that'll end the hearing for Senate Bill 933. We'll now move on to Senator Folden with Senate Bill 739.
Good afternoon, Mr. Chair, esteemed colleagues from Judicial Proceedings. For the record, Senator William Folden, representing District 4 in Frederick County. The bill before you today, SB 739, deals with the warrantless arrest provisions surrounding domestic violence. So what we're seeing is in law enforcement, they're seeing a lot of issues where we have, there's certain parameters where a police officer can make a warrantless arrest regarding domestic violence. Those are if the person battered is the person's spouse, if they reside together, which could include roommates, which is something I'll get into later, or what it doesn't provide for is those relationships where we have an intimate relationship between two consenting adults and it turns violent in the time after the intimacy occurs within a year. There's no provision for a warrantless arrest on that. This is something that is an important and meaningful piece of legislation to really just do a cleanup to say that if you are in an intimate relationship with another who you don't reside with, and that person then turns to violence in an effort to control or interfere or intimidate, that within the last year, that you would be entitled not only for it to be a person eligible for relief, but you would also be someone that could be, that the police, as long as the alleged complaint or alleged incident is filed with the law enforcement within 48 hours, that the person could have a warrantless arrest consistent with the injuries suffered by the victim. The one piece of cleanup in this is what I was just trying to get clarified, and I've spoken to some of the advocates about it, is that under current law, another person with whom the person resides could be roommates. This is not the intent of the original language of the domestic violence article, where for the purposes of a warrantless arrest, just because I'm a staunch Eagles fan and the Eagles are an amazing football team, and say the chairman is my roommate and he's a Commanders fan, he and I don't have an intimate relationship, but because I'm obnoxiously over the top irritating him and he hits me, that in current law would be a domestic violence assault. That is not the intent of what domestic violence is. That should be an assault, but it should not be a domestic violence assault with the other restrictions that go with that. So what I would recommend, what my recommendation is to add that it would, I'm sorry? Oh, sorry. Would be that another person eligible for relief under 4-501M of the family law article, and that would be all those that are currently listed as members eligible for relief under domestic violence law, but it would exclude the roommate situation that I just gave you and not put that into the domestic violence realm. And with that, I'm happy to take any questions, and I would ask for your favorable report on SB 739.
Senator James.
Thank you for bringing this bill. I think it's important. I see you have a lot of support across across our state.
I know.
Good for you. I just wanted to make sure that, I get that we need to do that roommate amendment to exclude that, right? But is the hallmark really, it's that the hallmark of creating protections is the intimacy that is either ongoing or was in existence up, as long as a year ago.
Correct.
What we want to get rid of is like, look, if you just live together and you're not into this, where passions, hatreds, love, hate, all that often are what lead to terrible circumstances.
Correct.
We don't anticipate that with, with regular roommates. That's what we're trying to do, right?
Yeah, matters of the heart are what are a driving force a lot of times, and especially when we're talking about a controlling environment where one person in the relationship is attempting to control the other after the relationship. And it doesn't always, at that point, isn't even an intimate relationship, but once it turns to that and that control continues or those acts of violence continue, that's what this would capture, is that there's no longer the part that would even require them to be living together, but that they have an intimate relationship and that the one turns violent towards the other and protecting the one victim.
All right, and this, as again, you're a police officer, I'm a lawyer, but I don't do criminal law. So the benefit of a warrantless arrest is that somebody does not have to go and before some commissioner to make a case, but you can basically call the police, and based on the statements by the victim or witnesses, the police officer can on the spot say, you know what, this person's getting arrested, and we'll deal with the rest of the case later. Is that the benefit of it?
So
I don't know what
that's part of it.
Okay.
That is actually part of it, but there is a responsibility of the law enforcement to corroborate and have and see evidentiary value of or evidence consistent with the complaint.
Oh, I didn't mean to sell them short, but you mean that
so there has to be a physical.
Right.
You can say certain things are happening.
Right.
If there's no physical evidence to corroborate that, then they may refer for services. They may refer for other, for protective order. But there has to be other binding elements. And it's in here. It says that there's the person eligible for relief, or I'm sorry, the person is a spouse. Another person would have had a sexual relationship, and then there's the part that it says there is there is evidence of physical injury, and unless the person is arrested immediately, the person may not be apprehended later, meaning may cause physical injury or property damage to another, or may tamper with, dispose of, or destroy evidence, and a report was made to the police within 48 hours of the alleged incident. So all these things have to kind of fit in that box together to get the warrantless arrest under these specific circumstances.
Sorry, I didn't read that part. Very good. Thank you so much. All right, thank you.
Thank you.
Further questions from the committee? All right. Excellent. Thank you very much, Senator. We'll now turn it over to our panelists joining us virtually. We'll hear from Ms. Stofa. Welcome.
Yes. I'm Tamara Stofa. I'm the District Public Defender for the 5 counties of the Upper Eastern Shore, and I'm asking you today to give an unfavorable report of Senate Bill 739. And my reasons for that are that it is, as currently written, it is overly broad, as there is no definition of a sexual relationship. Although the senator indicated that sexual relationship means an intimate relationship, there currently is no definition that's given. And therefore would allow individual police officers to decide what they determine is a sexual relationship. That could mean one encounter within a year, because there is no definition. The current law is very clear. It has to be a spouse or someone that currently resides at the residence. For those reasons, the overbroadness of this, I'm asking for an unfavorable report. Additionally, this bill does request an amendment of Family Law 4513 to change the definition of domestic violence. The current policy of the General Assembly under Family Law 4514 finds that victims of domestic violence have to leave their homes to ensure life and to secure their welfare. It also finds that victims and children economically are dependent on abusers and have no place to live outside the household. And as a result, it creates funding resources. The classification that we want to add to, again, not having a definition of a sexual relationship would expand the group of people that the General Assembly's policy, it conflicts with the current General Assembly's policy, because these are people that do not reside with the alleged batterer and the alleged abuser and have their own households. I would additionally indicate that there are avenues such as protective orders for people that are in these positions. But again, because there's thank you.
Thank you very much, Ms. Stofa. Questions from the committee? All right, thank you very much. All right, with that, that'll conclude the hearing for Senate Bill 739. We'll now move on to Senator Folden with Senate Bill 874.
Thank you, Mr. Chair. Esteemed colleagues of JPR, again, for the record, William Folden, Senator representing Frederick County District 4. Before you today, SB 874 regarding gift card crimes. Gift card fraud is more than just a retail issue. It's a well-organized operation that fuels broader criminal enterprises. Criminals steal gift card balances, use them to purchase goods, and profit by selling those goods on the secondary market. Without decisive legal intervention, these schemes will continue to harm businesses, consumers, and the integrity of the retail industry. There is a need for stronger deterrence. I urge you to support SB 874 that will provide law enforcement with the necessary tools to investigate, prosecute, and deter gift card fraud. We've attempted to insert the bill into existing credit card statutes, but after further review with stakeholders, it is agreed that the set of amendments that has been shared with the committee would address all issues, including the criminalized gift card tampering, which is classify gift card tampering as a crime and assign the greatest value to stolen open loop cards to ensure consumers retain access to secure and trusted gift card products. Criminalize the unauthorized use of these gift cards, establish clear penalties for the unauthorized receipt and use of stolen gift card redemption information, addressing gaps in current state laws that make prosecution difficult, and the targeting of the victim-assisted schemes, ensuring law enforcement has the authority to prosecute those that perpetrate fraud and who deceive the victims into providing gift card redemption information under false pretenses. And with that, this important bill in closing these gift card theft schemes and protecting our victims is an important step in moving forward to making or doing away with this criminal enterprise. So with that, I would ask for your favorable report on SB 874.
Good afternoon, honorable members of the committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance. We are in strong support of this legislation. So last year, Maryland became the first state to pass stringent gift card packaging laws. But despite the ongoing efforts of card issuers, retailers, and law enforcement to combat this criminal activity, fraudsters continuously adapt their tactics. They circumvent existing safeguards, and they do stay one step ahead of our industry efforts. So to combat this crisis, legislative action is required to strengthen protections, enhance law enforcement capabilities, and impose clear criminal penalties for those who are engaged in gift card fraud. Maryland actually already has statutes on credit card tampering, fraud, duplication, and more, but the problem is that gift cards do not meet this definition. And gift card scams take many forms, including tampering with physical cards, tricking victims into purchasing and transferring gift card balances under false pretenses, and stealing redemption information to make unauthorized purchases. All of this, by the way, is detailed for you in written testimony I submitted to the committee. You have a PowerPoint presentation and written testimony as well. The industry has already partnered with Homeland Security investigations through Project Red Hook, an initiative that's already led to the arrests of 150 people since its launch in January. Through those arrests, data is emerging that criminal enterprises use gift card fraud to finance illicit activities, including fentanyl production and distribution, money laundering, human trafficking, and illegal migration. Finally, fraudsters often use to purchase goods with stolen gift card balances and resell them on the secondary market, making it very difficult for law enforcement to track. I will go ahead and stop there. I'm glad to answer any questions. Thank you.
I don't know if this is for you or maybe the senator. What laws can be used to prosecute gift cards, thefts, tampering, duplication, redemption, theft card, draining, et cetera?
So if you look in the PowerPoint that I gave you some of the federal statutes that have been used to apprehend and charge criminals. Okay. But our problem is that we cannot use existing credit card statutes, probably for two reasons. First of all, gift cards are not revolving lines of credit. And you heard it referenced from Senator Folden in his testimony, you have both open loop and closed loop gift cards. So open loop are kind of those Visa gift cards that you purchase, and they're cash and they can be used anywhere. And then you have what we refer to as closed loop. So that would be a brand or retail specific or restaurant specific or gaming specific entity. And they're not issued to an individual. So those two criteria that exist in our current law and credit cards, we just couldn't use existing statutes. We had an organized retail crime conference. We hold one every single year, and this crime keeps occurring in numbers that you just can't believe at this point. And so we talked about with prosecutors, with law enforcement, with asset protection, what is it that we can charge individuals with? And we figured out that we don't have anything. So in fact, there's about 17 states right now that have introduced the amendment portion that's before you.
Okay, as I look through the PowerPoint, where can you walk me through the gift card tampering part of it?
Yeah, sure. So tampering is probably one of the most common schemes that you see, although I know AARP is going to talk about some of the fraud that's occurring with seniors. I know many folks are aware of that. But if you look on the method of operation, so, and I'm so sorry I did not put a page number for you, but it's page 3. In short, we have individuals that come in and they steal gift cards. They then take them out of our store. And so even if we catch them right then and there, the gift cards have no value. So there's nothing that we can charge them with. So we catch you with 50 gift cards, you're taking them somewhere, there's nothing we can do. So they take the gift cards, then they process them is what we call that. And they take predominantly the redemption information off the cards, and they take that sensitive information and they plug it into a system. They repackage those gift cards. They use our same glue, our heating elements, the security covers that we use predominantly on a redemption information. They will repackage them and bring them back into our stores and put them on the rack. So you'll go in to purchase something for a family member, birthday, holiday, whatever it is. And typically the second that that card is swiped, there's a system pinging it. And the second that money goes on that card, that money just went elsewhere. And so you give that card then to your family member, and it is void of value completely. So that's what that tampering portion looks like. And you can see too kind of the roles of the organization. Yes, this is going to be reminiscent of organized retail crime. This is a subset. Obviously, the feds are involved now. This is that serious. But you have the takers, the tamperers, you have drivers and placers involved. It may not be the same individuals, checkers and the monetizers, so people selling things or acquiring things with the tampered with gift cards, and then the leaders of these operations. So they are advanced. That's why HSI has this separate Project Red Hook investigation going on right now.
So is this like just one type of a scheme, or are there multiple? And I apologize, you may have talked about that before I came in late. So
in my 2 minutes, I could not get all of this out, so I really do appreciate the opportunity to talk about this a little bit. So if I could refer you to my written testimony. So gift card fraud actually falls into 7 different categories of theft schemes. And so when we wrote this amendment that you all have, we're able to capture all 7 of those categories within those 4 areas of charges. So that's why this had to be completely rewritten. But if you look there, it's a whole bunch of different techniques that they use, from tampering, duplication is another one, or tricking seniors would be a really great example into going in, purchasing gift cards, turning over the gift card information, and then losing that money.
Just anecdotal, my mother loved to give out gift cards and mail them to the kids and all that kind of stuff. And she ended up getting wrapped up in having money stolen off of cards that she had then given to the kids. So,
yep.
The
more and more
moral
common.
of the story was that mom and dad was there to pay the difference, so they still got the product that they wanted.
Yeah.
But it was obviously very, very, very concerning to my mother. So.
A lot of times it's not even reported to, because people will receive a gift card for a holiday or as a present and put it in their wallet or somewhere else. And then they go to use it and they're like, did I already use this? Well, there's no money on it. I guess I already used it. Oh, well. And so then they don't report it. So that's something else that we see that's common.
Cool. Thank you. Thank you, Mr. Chair.
Thank you. Just a couple of questions. I'm looking at page 2, lines 26 through 20. Actually, I guess we'll go over to
Of the
page
bill
3.
or the amendments?
The bill itself.
Okay.
Just as a part of the definition of what a gift card means.
Yep.
Could you explain what you're trying to do in Roman 2?
So ideally, I think what we do here, our original idea was to try to insert this into existing credit card statutes. And we came right up against deadline and realized it really doesn't belong in existing credit card statutes. And I will say probably one of the reasons that this committee isn't going to like is because most of that is a felony. And what we're talking about here is misdemeanor. So we would be really interested in the committee focusing on the amendments, because the way the bill is written, it doesn't fully capture all the different types of fraud that's going on.
All right, where are the amendments?
They should have been sent to you, Senator Folden.
Is it a part of your testimony?
Okay. Separately, did we
You don't. Okay.
get the amendments to the, okay.
Well, let me ask you this. And
Sure.
Is the definition of gift card the same in the amended bill versus?
No, actually, and
I'll
that's,
set that aside then. Don't worry about it. Thank you. Appreciate it. No worries. The other question that I had, and I appreciate you explaining how this worked, because I was trying to understand an example of what happened. So you were saying that if someone were to take a bunch of the cards and leave, you couldn't do anything with that. But I'm wondering why that is not theft. Just the taking. I mean, there's value to those, even if the value may be a penny or whatever. It's still a theft, right?
I mean, this would be theft under $100, right? Like, it would be petty theft, which is not something that we're interested in pursuing. And we, as retailers,
but it still is a theft.
It is theft.
All right,
it is.
Okay, thank you.
Yeah.
Oh, I guess it's not so relevant to the bill, but so I'm never going to use gift cards again. I mean, what happens that, I give them to my children and they, 6 months later they use it and they find out there's no money on it and they know they have not used it.
Right.
Not, you have money in a bank, the FDIC will reimburse you for some of the fraud. What happens to the poor, innocent customer that got this?
So a couple of things, and it was funny because definitely around the holidays, there was a lot of media interest around this. There always is. Recommendation number 1, keep the receipt. Put the receipt with it. That's something that we always recommend. Wow. Secondly, look for the tampering period. In the bill, by the way, that passed last year with regard to packaging, our industry agreed to training for all of our employees, and you will see signage that rolls out where consumers will see, like, please look for tampering on the cards. If anything seems off, we want to try to capture those cards.
I see that? Because I see these a lot in grocery stores, drug stores.
Yes.
And, they're all, a lot of them are coming at you. I can be very inattentive, but I haven't seen anything that says, hey, look for tampering. Is that going to be rolled out? Is what you're
Yeah,
saying?
so October, this comes into effect. But you're onto something here. We talk about this with regard to signage, and typically we oppose signage because our stores are very busy, and we have
Yeah, they
mandates on
are,
a whole bunch of other signage too. So that's not necessarily the most effective. There will be warnings on gift cards themselves to remind consumers too. And then the bill that passed last year mandated additional security protocols for redemption information. So you will see different types of packaging that's coming out too. So again, industry is doing everything in our power, but our frustration is we're making all of these changes. They're keeping up with us. We have nothing we can charge them with when we catch them.
So because I was trying to read the bill and the testimony and look at your wonderful PowerPoint, I missed just one thing, and I really don't want you to take too long. But you say that gift cards are valueless until, brought up to the cashier and, certain actions are taken, and then it has a value to it.
Yes.
But many of the criminals grab them right off the shelves and do their tampering, and you are getting in between that moment and saying, while it looks it's not valueless because the potential for theft is enormous. But just in general, you're going to say, look, when you take that, it's because of the potentiality of the value. Yeah. Is that what you're doing? And saying that potentiality shouldn't be treated as de minimis or whatever, and you've given some kind of value to it, and then we're criminalizing it.
So there are 4 separate areas
I don't want you to
that
repeat
we
it.
could charge.
So
No,
bad.
it's okay. No, I appreciate this, and I'm very sorry that you all don't have the amendments before you.
Okay, that's probably what I need.
Acquiring the redemption information itself would be one charge. Altering or tampering with a gift card or its packaging would be separate. Devising a scheme to obtain a gift card would be another one. And then a person with the intent to defraud could not use for the purpose of obtaining money, goods, services, or anything else of value, and that actually speaks to the senior
That does make sense, but here's what I'm struck with.
Yep.
Like, let's say, yes, I get all that. I just catch a member of the team in the store, and they got 100 gift cards all over their body. It seems to me what you're proposing now would require, I'm thinking that they'd have to be further along in the scheme for you to show this. Is that right? Is that what you're going to do? Or were you trying to up the penalty right there for just having 100 gift cards that you just stole off the shelf?
We would have to be able to prove intent to defraud or intent to commit a scheme. So we don't want to just be able to grab somebody. Now, for the most part, and I've shared that, we know when you're walking out of the store with 50 gift cards, what you're doing.
What else are you doing?
Exactly. Why do you want cards without value? What else would someone be doing? So.
All right. I'll think about that. Thank you.
Thank you.
All right, thank you very much, Senator James. Anyone else? No further questions? Thank you very much. Thank you.
Thank you.
All right, is Karen Morgan here? And then we just have here. Morgan, welcome.
Yes, thank you. Thank you again, members of the committee, Chairman Smith. For the record, my name's Karen Morgan. I'm a representative of AARP Maryland, here to testify in favor of Senate Bill 874. We also testified in favor of this bill on the House side, the cross-filed bill. And from AARP's standpoint, we have had a mantra since 2021. Gift cards are for gifts, never for payments. And in our presentations to people, we have constantly hit on this theme that if you are using a gift card to pay any kind of debt, that's a problem. And I was here testifying on Senate Bill 905, and I happened to mention that my mother was victimized by the grandparent scam. What she used to pay the criminal was gift cards. Now, why gift cards? Because they're virtually untraceable. They can be used to move small parcels of money very quickly. And the likelihood of people being able to get a refund once their card has been compromised is very, very slim. So criminals love gift cards. We have found, even though we've been beating this drum for at least 3 years, that we can't educate our way out of this problem. we were very proud, AARP was very proud to stand in support of Senate Bill 760 from 2024, the Gift Card Scams Prevention Act of 2024. And as the previous witness mentioned, that will set up training programs and signage and set up tampering standards, anti-tampering standards, but we can't just educate our way out of this problem. We need to close the circle with specific crimes that can target these criminals so that maybe they get the message to stop. So with that, we'd like to ask for a favorable report on Senate Bill 874.
Thank you very much. Questions from the committee? All right, seeing none, thank you very much. Thanks. With that, that will end the hearing for Senate Bill 874. Thank you very much, Senator Folden. We'll now move on to Senator Henson with Senate Bill 889.
Thank you, Mr. Chairman. I believe I have a panel joining me as well. Thank you. For the record, colleagues, I am Senator Shanika Henson, representing Legislative District 30, here to present Senate Bill 889, Criminal Law Distribution of Students' Personal Identifying Information Prohibition. So this bill seeks to solve the very real problem of doxing that occurs for students. You can imagine that if a person gets a hold of your personal identifying information and they have the intent to harm, that this harm could be rippled and tripled if you are a student who's seeking to further your education. Colleagues, if you aren't familiar with the term doxing, it means the action or process of intentionally, maliciously publishing private or identifying information about a particular individual. We know that students are most vulnerable, facing that by classmates, outside sources, and internet trolls. For example, last December, the University of Maryland had 2 egregious doxing cases that led to death threats against University of Maryland students. Upon further investigation, UMD campus police confirmed that the state of Maryland currently has no anti-doxing laws. That puts us out of alignment with 19 other states that have anti-doxing laws, but we here in Maryland have not caught up to those other 19 states. The purpose of this bill is to prohibit a person or groups from distributing personal identifying information or images of a student enrolled in an institution of secondary education or an institution of post-secondary education with the intent or knowledge that the information will be used to harm the student, or with reckless disregard for the risks that the information will be used to harm the student. It makes the person who does this in violation of our law subject to a misdemeanor crime with imprisonment up to 1 year and a fine up to $5,000. This bill offers vital protections for our students and their sensitive information. Why do we need this bill? Maryland's current laws against cyber stalking and harassment have many gaps and simply don't go far enough. For example, Grace's Law was originally enacted in October 2013 to address the changing digital landscape, making the misuse of internet-based communications to intimidate or harass a minor a criminal offense. It was enacted in response to the tragic suicide of Grace McComas, a 15-year-old girl from Howard County, Maryland, who was cyberbullied relentlessly, and she wound up taking her own life sadly in 2012. Her parents, especially her mother, Christine McComas, advocated for stronger laws against online harassment and cyberbullying after discovering that Grace had been the subject of months of persistent online abuse through social media. In 2019, Grace's Law was strengthened, increasing penalties for cyberbullying and expanding protections for minors. Senate Bill 889 seeks to build on that great work of Grace's Law and provide protections for students in both secondary and post-secondary education. And Mr. Chair and colleagues, I believe that what you'll learn from the testimony as well is that this issue disproportionately impacts certain students who may be more vulnerable based on their identity, based on their ethnicity, based on their closely held beliefs. And with that, colleagues, I'll turn it over to my panel and ask for a favorable report on Senate Bill 889. Thank you.
Excellent. Thank you very much, Senator. And just as a public service announcement, thank you all for the folks that were here and who are advocating for the bill, holding up signs. We just typically don't allow that in committee because we'll have fat heads and huge signs. And so we encourage you all to definitely display those signs in the antechamber, take as many pictures, and put that on social media for your support for this bill. But just in the committee room, we kind of limit that activity. So thank you, though, for your advocacy. And move on to the next panel. Ms. Chaudhry.
Good afternoon, Chair Smith, members of the committee. We want to first extend our thank you to Senator Henson for her leadership on this issue. My name is Zainab Chaudhry. I'm here today on behalf of CARE, the Council on American Islamic Relations. We are the nation's largest Muslim civil rights and advocacy organization. I wish that I was here today before you on an issue that was much more pleasant than the issue that we are here before you on. Maryland does have some of the strongest anti-bullying laws in the country, but unfortunately those laws, as Senator Henson mentioned, simply do not go far enough. There are existing gaps within these laws that need to be bridged. My organization tracks the prevalence of hate bias within our state, and across the state in 2024, our organization recorded over 600 incidents of hate bias incidents, discrimination, requests for assistance from community members, Muslims, Jews, Arab Christians, and Arab Muslims from across the state. And this is the highest number that we've ever recorded. And of this number, about 16% of these included incidents regarding cyberbullying and bullying of children, of students in both in secondary and post-secondary education. One of the things that really sets this bill apart is that it builds on, as was mentioned, on the Grace's Law legislation that was passed within our state. We currently have protections for minors, but we do not have protections for students in colleges and universities who stand to be adversely impacted. Many of these students exist at the intersection of numerous marginalized identities. And those students deserve our advocacy, they deserve our voice, they deserve your support to help pass this legislation. If Grace was here today, she would be 27 years old. If Grace McComas was here today, she would be 27 years old. Her mother and her family deserve to have her here. Similar to Grace, every single student who we have spoken to over the last 2 years deserves to have the same protections. And it is unacceptable that our state currently does not have those protections. We have confirmed with University of Maryland Campus Police that our state currently does not provide protections, even for students who are facing death threats in circumstances beyond their control. And you will hear testimonies here today before you from some of those students, but I will share with you that many of those students, the vast majority of them, Jewish, Muslim, Arab, from diverse backgrounds, they do not feel comfortable and they do not feel safe coming forward. So I urge you to please pass this bill. Thank you so much. I know I went over my time. Thank you.
Hi, my name is Ikram Abdu, and I am a student at the University of Maryland, College Park. I'm here today to express my strong support for Senate Bill 889, which seeks to protect young individuals from the harmful and dangerous impacts of doxing. We live in a world where almost everything is digital. Social media is not just for staying in touch, it is where we network, apply for jobs, express ourselves. But for some, it is also where they become targets. Doxing does not just expose information, it puts real people in real danger. No one should have to fear for their safety just because they have an opinion or express their beliefs. Disagreements should not turn into personal attacks, but doxing takes private details and weaponizes them, leaving people vulnerable to harassment, threats, and real-world harm. I know firsthand how devastating the consequence of doxing can be. Recently, I was falsely accused of an act I did not commit, and my full name was shared online alongside inflammatory allegations. As a result, I was subjected to an overwhelming wave of online harassment, including death threats and messages from people claiming they would report me to my university and contact my past employers. I was forced to deactivate all my social media accounts and wipe my digital footprint to the best of my ability. The person who made these false allegations reported me to the UMB Campus Police and to UMB Title IX, which led to an official investigation. After a thorough review, I was found innocent. However, instead of accepting the outcome, she retaliated by doxing me, publicly sharing my personal information online in an attempt to ruin my reputation and put me in danger. This led to even more harassment and threats, making me fear for my safety online and in real life. Sorry. Doxing completely upended my life. It put my safety at risk. It cost me job opportunities. It took a toll on my mental health, and it disturbed my education. I used to freely share my beliefs in real life and online, but now, like many young people, I hold back from sharing my opinions or engaging in informed conversations out of fear of my personal information. This bill is a crucial step in protecting individuals under 25. Can I stop? Okay. Okay, thank you.
Good afternoon. Thank you, Chairman and committee members, and thank you, Senator Henson, for sponsoring this bill. My name is Iman Shahadi. I am a current student at the University of Maryland, College Park. As a community member actively engaged in advocacy, I have seen how doxing is a real threat to safety and leads to loss of employment opportunities, mental health struggles, and disruptions in education. Many young people fear expressing their opinions and participating in civic engagement because they know that their personal information could be exposed and used against them. This bill provides a crucial protection and safeguards for students from those malicious attacks. Holding perpetrators accountable through this legislation sends a very clear message that weaponizing personal information to intimidate or harm others should and will not be tolerated. I have had personal instances of threats of doxing. I have not been doxed myself and have had close friends and family members been fully doxed online and have it lead to threats of harm and death threats in very similar situations. And especially people's information being posted on online forums for other people to further harass and send intimidating messages to. I urge the committee to support this bill and help create a safer and more secure environment for young individuals across our state. Thank you.
Good afternoon, Chairman Smith and members of the committee. Thank you, Senator Henson, for sponsoring this really crucial bill. My name is Kimberly Suardi. I'm CARE Maryland's Outreach Coordinator, and I recently graduated from the University of Maryland in College Park. As a recent graduate and activist, I'm here today to express my strong support for SB 889. This bill is crucial to protect our youth from the detrimental effects of doxing. I've personally witnessed the severe harm that doxing can inflict. Friends of mine have been targeted simply for speaking out on social and political issues, their personal information, such as their home addresses, phone numbers, and workplaces being exposed online without their consent. And as a result, they face relentless harassment, including death threats and online abuse that made them fear for their safety. Many young people fear expressing their opinions or participating in civic engagement because they know that their personal information could be exposed and used against them. No one should have to live in fear because their private information has been weaponized against them. Doxing is not just an invasion of privacy, it is a form of intimidation that silences voices and puts lives at risk. I urge you to please support this bill to help protect people from being targeted, threatened, and silenced simply for existing or expressing their own beliefs. SB 889 is crucial to step in ensuring that individuals have legal recourse against this form of digital harassment and that those who engage in doxing are held accountable. Thank you so much.
Excellent. Thank you very much. Questions from the committee for this panel? Senator Sidnor.
Thank you very much. Am I as well? So I'm looking at page 3, lines 23 and lines 25, where it talks about information or images used to harm. And I'm wondering, what does use to harm, what are we trying to capture there?
We are balancing free speech and a person's right to communicate information, even information that we might find that's sensitive information, but it's not covered when it is the malicious intent that's there and when that information is used to harm. So the use to harm standard is what gets us around balancing the rights of the person who is the communicator of the speech and the rights of the person that are harmed. The language of suffered harm is not dissimilar to other parts of our code where something becoming a crime is the result of the harm that results, where on its face, if it's done but there is no harm, then there is no criminal liability. So here, that's what the designation of harm is designed to flesh out.
So Joe Schmo hates dogs. I put this online, but I sent it to a group of students who I know love dogs. Joe Schmo starts getting emails and all sorts of comments about his hatred for dogs. Would I be in violation? Because I said, find Joe Schmo and on Alamo Street. He hates dogs, and I love him.
So I think one of my panelists wants to respond, but in addition to, and if the chair will permit 2 responses, in addition to that, it would be a determination of harm there. If people contacted Joe Schmo and said, I disagree with you, I really like animals, even though you don't, what you would be looking at is that sort of communication with him that harasses, that annoys, that sort of communication that causes a harm to him. If there's some sort of detriment, let's say he loses a job because of that, or he suffers mental unwellness because of that, or some other discernible harm that could be proved in court, that's when that communication would cross the line from simply being one to another to something that's harmful.
And that's why I was trying to understand harm, because I know many of us have received all sorts of messages from people online, and we've had them people saying, you know what, maybe it was a racist comment or something that was put out there. Let's find out where he or she works, and we're going to contact their employer. They've lost their job. There was a harm there. If that person was a student, I'm just trying, and I know when I initially heard about this bill, I was having an internal struggle with trying to understand and doing that balancing of the First Amendment and also trying to deal with the harms that I know doxing causes. So that's what I'm still kind of trying to tease out and understand with the question. So if that person who wrote that racist comment, the individuals who then went online because we found out this was a student, they violated this proposed law?
So it would depend if the comment were racist and it also included their personal identifying information, and it was being exposed in that comment, and then as a result of that personal identifying information or that image being shared, that person was harmed and that person was a student, then under your analogy, that's correct. That actor would be subject to criminal liability under the bill.
Thank you.
Thank you.
Excellent. Further questions from the committee? Seeing none, thank you all very much.
Thank you.
Yes, ma'am. Come on up.
Hi, thank you for letting me talk today. My name is Rachel Turner Seward. I am an IT employee for the U.S. House. I'm here today to express my strong support for SB 889. This bill is a crucial step towards protecting young individuals from dangerous impacts of doxing and ensuring that there are structures in place to hold perpetrators accountable. I wanted to share a personal story from my own experience with doxing. When I was 18 years old as a college student, I sent a private message to a friend, and without my knowing, that message was posted online with my personal information, with all of my family and all of my professors tagged to this message. And I remember the moment, my mom called me and told me what happened and that she saw this, and just world-shattering horror as, I realized all of my professors saw it too. This majorly impacted me mental health-wise, as well as within my college education. This was right at the beginning of my time in college, and it was pretty traumatizing. I was very lucky, and I'm very fortunate that my family stood by me and offered me love and support. I still have a physical letter my aunt sent me, saying that they love and support me even through this. But this could have easily been something much more traumatic and much more dangerous. And it's also, this was 12 years ago. It's only easier now for these things to happen. So yeah, I support SB 889, and I urge you to do too.
Good afternoon. My name is Noor Dawood, and I am a student at River Hill High School. I'm here today to express my strong support for this bill, which seeks to protect students and young individuals from the dangers and severe impacts of doxing. In today's digital world, a person's information is more accessible than ever, and young people especially are vulnerable to having their private details exploited maliciously. Doxing, which is internationally disclosing someone's personal information without their consent, can be used as a weapon for harassment, intimidation, and even physical harm. Unfortunately, students and young professionals, particularly those involved in advocacy, journalism, or public discourse, are frequent targets. As a student and member of my community, I have witnessed firsthand how doxing can severely and majorly impact someone's life. Several people I know have been doxed, and the consequences have been devastating, ruining reputations, limiting career opportunities, and in some cases, leaving individuals fearful for their safety. These experiences have caused many students to become hesitant or outright fearful for expressing their opinions or participating in public discourse because they know their personal information could be exposed and used against them. This bill is crucial because it provides the necessary protections for an individual under 25, ensuring that young people can engage freely in civic life without having the fear of having all their information leaked. It would give them the peace of mind to express themselves, knowing that there are legal protections in place to prevent their personal information from being weaponized. The fear of doxing is not abstract. It's a very real issue that affects students' mental health and well-being. Many are afraid to use their constitutional rights or to stand up for their beliefs, as they are worried that in doing so they could put their personal information at risk. Passing SB 889 would send a strong message that Maryland stand with its young people, ensuring that rights to free expression and safety are protected. I urge the committee to support this bill and take an important step in creating a safer environment for young individuals in our state. Thank you for your time and consideration.
I'm Shelley Cohen Fudge. I'm with the DC Metro chapter of Jewish Voice for Peace, which represents Montgomery County and PG counties, as well as DC and Northern Virginia. We fully support this bill, and we thank Senator Henson for introducing it. Doxing is a serious form of harassment. It's intended to intimidate and harm someone online. It can be very cruel, as some of the other folks here have spoken about. It can escalate into stalking and threats to the physical safety of the victim and result in very serious emotional distress to them. It particularly impacts youth and has become increasingly prevalent in Maryland's high schools and on college campuses. Students who express support for pro-Palestinian freedom and human rights are particularly targeted for doxing, including Jewish students, among others, who criticize Israel's policies. If enacted, we believe this bill would provide protections for those under 25 years old from doxing, and thus would go a long way to safeguard them from being targeted by vicious doxing perpetrators. Thank you.
So good to see you, Shelley. Questions from the committee? All right, come on up. Who else is here to testify in favor of the bill? Is anyone else here? Okay.
Thank you. Good afternoon, Senators. My name is Laura Wilt. I'm a Chief Juvenile State's Attorney in Frederick County, and I'm here expressing support for this bill, 889, on behalf of Frederick County and the Maryland State's Attorneys Association. I have my testimony, I believe, will demonstrate that this bill fills a gap in a slightly different way, which allowed, we had a situation which allowed an individual in our community to use the names and photos of 5 young girls to open over 75 different accounts online. He opened Pornhub sites. He opened repeated social media accounts and websites. He used their name, he used their images to falsely act in their name online, to engage in sexually explicit conversations, to talk about sexual liaisons. He used their names and images to promise pornography exchanges, all with reckless disregard for the impact that it would have on these girls. These 5 girls and families have spent countless hours and a lot of money trying to get these websites taken down. Still, their names and likenesses have accounts open on OnlyFans and other porn sites. For example, their name and likeness is out there with, the caption, lover of all things kinky. These girls have been contacted because these are their real names. So men have tracked them down on their real accounts, reached out to them, and tried to follow up on these relationships. They have been scared to be alone out because they're waiting to be contacted. The current law prescribes identity theft, but only if done for financial gain. So in our situation, this person used their identity for their own gratification with reckless disregard for what it did to these girls. So I thank Senator Henson and express our support for this legislation. I would, if I could, Chairman, I just wanted to note that one of the victims of this crime, Rachel, submitted a letter. She drafted it, and she submitted it under the wrong bill number. So it was under 905, so I don't know if I could read a couple paragraphs, or I could ask you to reference.
We'll make sure that it gets into the bill file.
I'm sorry?
We'll make sure that it gets into the bill file.
It was under 905, and it was from Rachel.
Okay, noted. Battaglia?
Yes,
Okay.
exactly. Thank you very much.
It's here. I have her sign up favorable with amendments. Rachel's obviously not here, though, right? Is that right?
That's right. She's
Okay.
not here. She thought she did it wrong, so she didn't come.
Okay, excellent. Well, we have it. We have it, so thank you for
All
that.
right, thank you.
So Senator West and Senator Sidor.
Thank you, Mr. Chair. I really love this bill, but my only concern is whether it sweeps too broadly. So I look at the list of things that constitute personal identifying information, and it says it includes a person's name and telephone number. So if I'm a high school student and a friend of mine says, gee, I'd like to call so-and-so up and ask her for a date. Do you have her telephone number? And I attach to my return email the card from my contacts that has her name and telephone number. As I literally read the statute, it looks as if I have violated the law by giving a friend her name and telephone number. I'm sure you don't mean that to be the case.
We have to prove intent. In this statute, you have to prove that you did so without the express permission, with the intent that it be used to harm them, on page 3, or with reckless disregard for the risk. So all that intent there would make that not a crime.
I see. And if my friend were in turn to share that posting with others, you don't think it still wouldn't cross the line into reckless disregard?
I don't see any intent there. So in my case, I would have to, our scenario, he created all these websites, used their name, used their picture for his own gratification.
No question, yours is, the example you gave is terrible.
Yeah, I think I have to.
I'm concerned about maybe it sweeps too broadly in other areas where we got to worry about unintended consequences of language we use. So that's what I'm trying to wrestle with.
I think that reckless disregard would make that a very hard case for me to even argue. How could I even argue that that was used with reckless intent?
Got you. Okay, thank you very much.
So I have a constituent who testified in support of this legislation. Yes. There's a website called Canary Mission that I believe many of the proponents, they may have found themselves on. Are you familiar with this website?
I'm not, I'm afraid.
All right, this website, I was to read the About Us. It says their mission is to document individuals and organizations that promote hatred of the U.S., Israel, and Jews on the North American college campuses and beyond. And it goes on. And right on, you go right on the first page, and there are pictures of a number of, just scrolling through, students with their club affiliations, their university affiliations, which I'm assuming is probably the impetus to this bill.
It does sound like that.
But the question that I have, again, it has their photos and essentially gives a dossier on each of these students and their activities that would have landed them on it. When I look at this, I'm wondering, going back to lines 21 through 25 is, trying to prove the intent. And I'm asking you as a prosecutor, if you were to see this type of website and this bill, if it was law, how do you go about proving intent or knowledge that the personal identifying information or image will be used to harm the student?
Well, me personally, I would look at the date that they posted that information and what else was on the website at that time. So when they were posting it, what was the other content? What was the purpose of that website? How can I show that it was clear that that website was made to target? So I have to look at what's publicly available on that website, use that information to show that was reckless. If you put that up there, seeing all the rest of the negative targeting content, if I'm understanding you correctly, I would have to bring in more than just you put the information out there. I would have to show the totality of the circumstances.
And I think I'm probably, at this point, with the way the bill currently is, I'm probably close to where my colleague is. I get it. I don't like what's happening to the students, but I also don't want to have a bill go forward and just kind of have these unintended consequences of capturing people that we don't and doing something that's possibly that violates the First Amendment.
Right. What I can tell you is that without that reckless disregard, we would not be able to help. We were not able to help these girls the way we should have, because we had someone who put it up for different intent. To prove someone's intent, what's in their head at the time they put it up there, is very hard. But if I can show what else is on that website, what is going on, what he knew at the time, can I show to a judge that there's reckless disregard? And there's probably, hundreds or thousands of cases out there that tell a judge what I have to prove to get to that level.
And I'm assuming with the current language of the bill, it's not necessarily just the initial poster, it's any reposters and the like as well that get captured under this language.
So I, as a prosecutor, can't use those additional things to show their intent, but I can show the harm that came to the victim as a result.
But no, what I'm asking is, I'm the original poster or creator of this Canary Mission website. My intent is to get after those people that I've put on the website. Senator Weston takes my website and starts sending out the link and says, look at this particular student. Is he now implicated under this legislation? I'm fully within it.
Right, he's sending it out.
To get him as well, right?
Well, if he's sending out their personal information in particular, and saying, look at this, I think he needs to, I think I would get to specifically what did he send and was it targeting someone?
Thank you.
Just sending a general link, I don't think rises to that level.
Okay, thank you.
Mr. Chair, sorry to come back again, but I'm noticing we have present with us a number of high school students. And I'm not so old that I can't remember being in high school myself. And in those days, I can recall that there were members of our class who did their best to tease, bully, antagonize, embarrass other members of the class. Now, in those days, we didn't have the internet. And I'm hard pressed to think what they would be if I were back in high school today with internet available. I'm assuming kids haven't changed. Still, when you're at that age, there are people in the class who like to bully and tease and intimidate and embarrass other members of the class. So when I was in high school, I would not have wanted those people who did that to be indicted and maybe go in prison for a year or subject to a $5,000 fine. I would have liked the school to have found out who they were and disciplined them in the school, but not in court. And I guess my concern about the bill and it spreading too widely and capturing people unintentionally who we really don't want to capture is that literally as I read the bill, it would have covered the people in my class way back when who engaged in bullying behavior, but would have used the modern technique of the internet to do it rather than the old technique of whispering and embarrassing stuff behind your back. And I'm not sure if you have any suggestions as to how we could amend the bill in order to make sure that high schoolish bullying behavior was not picked up by this in a way which would incriminate high school kids who we really don't want to incriminate.
And in my case, it was high school kids. And, you know, it was, again, not to harm these girls, but with reckless disregard. And there's no crime that covers this at all. It made his actions completely, we couldn't even have an officer send letters. They sent letters, but we couldn't allege a particular violation of a law. So at this point, this action is completely, like you said, you hope there would be some consequences. There couldn't be under the current identity theft statute. So your question, I don't know if the senator has thought about that issue or addressed that issue, whether it needs to be narrowed. I feel like the intent and the recklessness here and the harm is identified and clear enough that it's not overbroad.
All right, further questions from the committee? Thank you very much. All right, I believe that's it. All right, with that, that'll conclude the hearing for Senate Bill 889. We'll now move on to Senator Waldstreicher with Senate Bill 709.
Yep, there you go. Well, thank you, Mr. Chairman, members of the committee. On behalf of the National Urban League, one of our nation's preeminent civil rights organizations, and the Anti-Defamation League, the nation's leading Jewish civil rights organization, I'm proud to present the Unmask Hate Act. Perhaps the most important coalition in the history of our country is the deep and long-lasting friendship between African Americans and Jews. And I want to talk through that history, the history of that coalition, and kind of tell it through the personal eyes of my grandfather, because the dates are important to provide context for the bill in front of us. My grandfather was born in 1912, and I appreciate the indulgence. This will come back to the bill in front of you. He was born in a small and poor Jewish village in the Pale of Settlement, which is just a complicated way of saying the part of the Russian Empire where they allowed Jews to live, until, of course, they didn't. And at the age of 8, in 1920, my grandfather, knowing no English and knowing nothing of the United States, fled violence and persecution and crossed the entire ocean for New York City. And there he grew up in a crowded, impoverished tenement of the city and surely noticed that there were other communities that were subject to the same ghettoization and conditions, including the African American community. And something was happening in New York in the 1920s, something important. In 1920, the National Urban League, who is here with us today, took its current form. And the 1920s was the decade in which the NAACP rose to prominence. That organization was founded by African-American New Yorkers like Ida B. Wells and W.E.B. Du Bois. It was also founded by Jewish Americans, including Henry Moskowitz, Joel Springern, who served as chairman, and Rabbi Stephen Wise. And the Urban League and the NAACP were vital to the future of the nation because of a masked and dangerous threat, America's first terrorist organization, the Ku Klux Klan. The KKK was actually formed in the postbellum period, but half a century later in the 1920s, they came roaring back. And it wasn't just in the South. This new KKK gained mainstream acceptance and terrorized northern and Midwestern states as well. Their acceptance is usually exemplified by the important but racist movie, Birth of a Nation, which President Wilson applauded. The Klan then was exactly what you think it was. Concealing their identities behind masks, they threatened, intimidated, and lynched African Americans across this nation. This photo in front of us is not Alabama, it's not Mississippi. That photo is Baltimore City in 1923. Let me go back to my grandfather. He was the first in his family to go to college at City University, but he was poor and struggled to find work. If you were Jewish in New York City, you had your options within certain industries that were ethnic industries, like bakers or furriers or tailors or diamond cutters. But my grandfather wanted to be, of all things, a grain scientist. But there was an employer, a big one, who was hiring not based on how you prayed or what the color of your skin was, but based on merit. And in the run-up to the Second World War, they were hiring Jews and they were hiring African Americans. And that was the federal government. And so my grandfather and grandmother moved from New York to DC and moved into an integrated neighborhood. And in the decade and a half after the war, as African American soldiers returned from a Europe in which they shared equal rights, from a war fought over the future of freedom, they returned to a nation in which those very freedoms were still tightly circumscribed, and the civil rights movement was born. And again, the friendship between the African American and Jewish communities proved meaningful. Living in DC, my grandfather and later my mother had a front row seat to all of it. The Urban League, the NAACP, and the newly formed Southern Christian Leadership Conference led the way. And as allies were organizations like the ADL and prominent Jewish communal leaders. Most famously, you see photos of Rabbi Abraham Heschel locked arm in arm with Martin Luther King throughout the South and in DC for the March on Washington. There was massive resistance to civil rights, violent resistance, often masked resistance, but for a time the arc bent definitively towards justice. But no victory is permanent, and today Jews, African Americans, and other vulnerable communities are again the target of those who would hide their identities. A new threat is rising. And again, masks are being used to threaten, intimidate, and harass. This is the Proud Boys. They are a hate group, a white supremacist organization. They exist only to cause violence. They are known primarily for brawling while masked with Black Lives Matter protesters. Also, while masked, they were a prominent part of the January 6th insurrection. This is the Patriot Front. They are just as dangerous, equally committed to mass violence, and openly fascistic in their ideology. They are a modern KKK, just replacing the bed sheets with pointy masks with khakis and balaclavas. And we know that masked harassment, intimidation, and threats exist across the ideological spectrum. We saw it on our college campuses. We know what happened at Columbia University. Former Senator Kelly's daughter saw that violence up close. But I was most troubled by what occurred at UCLA, where masked counter-protesters stormed a peaceful pro-Palestinian encampment with bats and pipes. And that's exactly what this bill addresses. It's about masked violence. It's about folks who maliciously conceal their identity with the explicit intent to commit violence or threaten violence or intimidate or harass others. Many states already have this exact law and have used them effectively for decades without issue. Why decades? For exactly the reason we explored here today. The Urban League, NAACP, and ADL passed these laws across the country in response to KKK violence in the 20th century. Why didn't we do so here? Because in Maryland, slavery was once legal, segregation was once enforced, and the KKK was once welcome. And so now it's our chance to pass this law. Now that you know what the bill does, let me tell you what the bill does not do. First, the bill does not criminalize masking. It criminalizes participating in existing crimes while maliciously concealing one's identity. The existing crimes are longstanding under Maryland law, well-defined in both our code and through case law, and require an enormous burden to prove. Two, the bill does not criminalize masking for health reasons. Separate from the fact that the bill requires a specific criminal mens rea, we also included a specific carve-out for those who must mask for health reasons. That's at line 29 on page 2. I hope you'll trust me, as someone with a chronic condition and as a father to a daughter who is also immunocompromised, I am deeply empathetic with those who are at real risk and need to mask regularly. And I want to express my sincere thanks for those who are joining us here today who share the circumstance with my own family. 3, the bill does not put a burden of proof on anyone to somehow prove their disease. The burden of proof remains on the state in all cases, who of course must first prove that the mask was worn with the intent to commit violence, intimidate, or harass, all defined terms. 4, the bill does not criminalize masked protesting. In fact, all of the examples we've seen are the exact opposite. It is counter-protesters like the Proud Boys and the UCLA defendants who attacked a peaceful pro-Palestinian encampment who would be subject to the provisions of this bill. Constitutionally protected speech, including masked or anonymous speech, remains inviolate. 5, the bill does not rely on the subjective feelings of the alleged victims. The law does not apply if you feel intimidated by speech with which you disagree, if you feel threatened by ideas you don't like. Subjective feelings are not relevant to prosecution under this bill. The bill relies on the objective intent and actions of the masked defendant. Did the defendant have the criminal intent and, in fact, threaten, harass, or intimidate while concealing their identity? That's the question that the state must answer beyond a reasonable doubt through objective evidence. Let me conclude with this. These are dangerous times. Hate has reared its head once again in this nation, but this is not without precedent. In the 1920s with the KKK and again during the Civil Rights Movement, African Americans, Jews, and all people of goodwill came together to say, not on our watch. You're about to hear from the Greater Baltimore Urban League, the Greater Washington Urban League, and the ADL. I hope you'll listen to their testimony closely. Together we can say, not on our watch. Together we can unmask hate. Thank you, Mr. Chairman.
Good afternoon, Mr. Chairman and members of the committee. My name is George Lambert. I am the President and Chief Executive Officer of the Greater Washington Urban League. As an affiliate of the National Urban League, we are a historic civil rights and urban advocacy organizations with 90 affiliates serving 300 communities around the country. The footprint of the Greater Washington Urban League is Washington, D.C., Prince George's County, Maryland, and Montgomery County, Maryland. I am here to offer my testimony in support of the proposed legislation prohibiting mass intimidation. Communities of color often face targeted violence from extremist groups that harbor racist ideologies. This violence can be manifested in physical attacks, hate crimes, even mass shootings, creating an atmosphere of fear and insecurity. Hate campaigns exacerbate the marginalization of communities of color, reinforcing negative stereotypes and societal biases. This can lead to further discrimination in areas such as employment, education, and housing, perpetuating cycles of poverty and inequality. Moreover, the rise of hate and extremists can erode social cohesion, making it more difficult for diverse communities to come together to address common issues, to advocate for their rights, and to build a more inclusive society. Addressing hate and extremism requires a coherent approach, includes education, community engagement, policy changes, and certainly promoting understanding and inclusivity as well. To be clear, we strongly support this bill that prohibits individuals while concealing their mass identification. I will stop there. I know I'm out of time, but I think you certainly understand the drift of my comments. Thank you.
Good afternoon, Chairman and the Senate Judiciary Committee. My name is Takia Warden. I'm the President and CEO of the Greater Baltimore Urban League. Our organization is dedicated to ensuring that African Americans and other minority groups achieve economic self-reliance, power, and civil rights. And every day we work to empower these communities across Maryland, transforming the lives of economic development, education, health, housing, workforce development, and entrepreneurship. I appear before you today to express our dedicated support for Senate Bill 709. As a civil rights organization with a century-long legacy, we have seen tremendous progress in combating systemic discrimination and advancing human rights. However, in recent years, we've seen a disturbing resurgence of hate-fueled threats, harassment, intimidation, and assaults. Many of these acts are perpetrated by individuals and groups who conceal their identities with masks while targeting vulnerable communities. The Greater Baltimore Urban League serves the entire state of Maryland, and we unequivocally condemn any form of hate directed to our residents, particularly those in marginalized communities. Today, your constituents who are Black, Jewish, LGBTQ, or members of other historical targeted communities remain unprotected from attacks by masked individuals. Maryland has been a leader in fostering inclusion, but we lag in establishing a criminal penalty for this kind of behavior. Without SB 709, victims face significant challenges in obtaining justice, and perpetrators act with impunity, emboldened by the lack of consequences. The historical precedent is clear. For generations, domestic terrorist organizations have used masks as tools of anonymity while committing heinous acts, burning crosses, lynching innocent individuals, and storming government institutions. This bill is a critical step in ensuring that such intimidation is no longer tolerated in our state. In today's climate, we are emboldened by bad actors seeking to instill fear, and Maryland must take a decisive action to protect its residents. Please support SB 709.
Good. Okay. Thank you, Mr. Chairman, members of the committee. For the record, Meredith Weisel with the Anti-Defamation League. Too often, masks are used as tools for crime of hate, lending anonymity to those targeting individuals or groups because of their backgrounds. This legislation will help protect our communities to ensure accountability while upholding free speech and health exemptions. This is also different than garden variety harassment because the fear of safety is about the mask itself. The masking is part of the intimidation. And we have seen bad actors using masks and face coverings to conceal their identities. They are deliberately harassing, intimidating, intimidating, and targeting others without facing consequences. With the resurgence of mask harassment, it's crucial that we restore and strengthen these measures to protect our vulnerable communities while allowing for exceptions for health considerations, religious expression, and many other areas. The original anti-mask laws include laws actually dating back to the rent riots in 1845, as well as mid-20th century laws, which curb the behaviors, as was mentioned, for the KKK. The bills were specifically meant to prevent mask harassment from engaging in public intimidation or violence. And the language of the initial laws, while they address how to deal with mask intimidation, did not provide exceptions to wearing masks as a public, as a group, or as an individual due to things we're seeing modern day here. Anti-masking laws can and must be narrowly tailored, as this bill is, to preserve freedom of speech and assembly. However, the exercise of free speech and assembly must not also infringe upon the rights and safeties of others. Therefore, this legislation pursuing takes into the consideration the evolution of society, but it also upholds our freedom of speech protections that are enshrined in the U.S. Constitution. Our goal is simple. Individuals and groups who engage in harassment and intimidation, who are fueled by hate and bias, must be able to not hide behind their mask to avoid the consequences for their conduct.
All right, excellent. Thank you all very much. Questions from the committee? All right, seeing none. Thank you all. Thank you. With that, that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. We'll hear from Serena Miller. Is Aaron Greist-Schwartzman here? Allison Eisberg? And Paul Lombard. Welcome. You can begin whenever you like.
Good afternoon. Thank you, Mr. Chairman and members of the Judicial Proceedings Committee. My name is Serena Miller, and I live in Baltimore City. I am here today because I oppose Senate Bill 709. My mother was diagnosed with cancer when I was young. My father had a stroke this past year. I myself take a medication that lowers my immune system response to diseases. My family and I wear N95 masks in all public spaces to keep ourselves and others safe. As a Jewish and queer American, I have experienced anti-Semitism and bigotry my entire life. With the current state of our country and politics, I live in a near constant state of anxiety and fear. The idea that I may have to sacrifice my health to exist in public only exacerbates this anxiety. While there are carve-outs in this bill for people who wear masks for medical reasons, it still appears it would be left up to the discretion of law enforcement to determine whether a person's reason for masking is valid. The language is broad. How would law enforcement make that determination? And should there be an instance where I am out in public in my mask and someone decides my mask itself is threatening, what is to stop them from utilizing this legislation to claim I am harassing them, even if the bill does not rely on subjectivity? This bill is supposed to protect Jewish people like me, but it would do the opposite. Most people I know who wear masks work in low-paying, customer-facing jobs. We have bills to pay, families to feed, pets to care for. We can't afford to be sick and out of work. We especially cannot afford a jail sentence or a fine. We should not have to compromise our right to publicly exist for our right to keep ourselves safe. I implore you to give an unfavorable report on Senate Bill 709. I thank you for your time.
Hello, my name is Allison Isberg. I live in Catonsville, Maryland, and I oppose this bill because it promises protection, but that is not what it provides. Instead, it only increases the danger of disease and harassment for already vulnerable communities, including some of the people its sponsors are trying to defend. I am disabled and immunocompromised thanks to several chronic health conditions. I've had COVID once. That was enough to permanently worsen my health and increase the already high costs of my medical care. 5 years after the start of the pandemic, I still live in partial quarantine. I still miss many social events and limit my activities based on COVID infection rates. The ability I do have to socialize or even exist in public comes from wearing a mask. It comes from my friends and family wearing masks. It comes from the many people I will never meet who mask to keep their community safe. The exception in this bill allowing for masking against the spread of airborne disease is wholly inadequate. Chronically ill people use masks not just against COVID-19, but also against allergens, pollution, and other dangers. Anything that limits our ability to mask or that might require us, however mistakenly, to prove our need to mask to a police officer is a serious threat to us. 709 also exposes the masking community to increased discrimination. Since 2020, anti-masking sentiment has spurred some to harass or even assault mask wearers. When a similar anti-masking bill was under debate in New York State last year, people who opposed the bill were yelled at, spat, and coughed upon and physically assaulted. The victims include a disabled Jewish woman. That law is now the subject of a class action lawsuit brought by Disability Rights New York. We must not allow our right to participate safely in society to rely on this inadequate bill and the assurances of its sponsors that it will never be misinterpreted. We must not give further leeway to those who would harass the disabled and their allies. My own Jewish ancestors came here so that they could live freely and safely. By rejecting this bill, you protect their descendants' right to the same. Thank you for your time.
Good afternoon. As a lifelong resident of Maryland, SB 0709 deeply concerns me. So few people still wear medical respirator masks in public, and yet we have been harassed, we have been threatened, we have been assaulted. My concern that if this bill becomes law, it may discourage people, including immunocompromised people, who choose to wear medical respirator masks in public from doing so. I'd like reassurance that if passed, this law will not give law enforcement discretion to approach, question, or detain anyone they encounter based solely on that person wearing a mask. We, by which I'm referring to people who choose to wear medical masks, wear respirators, such as the one I'm wearing now, in order to reduce our risk of infection at a time when contagious illnesses like flu, COVID, norovirus, H5N1, measles, etc., continue to spread across the country at alarming rates. My wife and I both became immunocompromised after we contracted COVID in December of 2023. She contracted it after going to a doctor's appointment at a medical facility that did not have a masking policy. This has had a profound and long-lasting effect on both of our qualities of life, and we expect it to continue to do so, which is why we simply ask when we go out in public, we would like to be able to protect ourselves by wearing something along these lines. We would prefer that we not be approached by police officers if we are simply going about our day and conducting our various errands. And we would also prefer that anyone who assaults or attacks us for wearing a mask be held responsible for those actions. Thank you.
Hi, my name is Erin Grice-Schwartzman. I'm a resident of Howard County. I am a public health policy professional with a background in disability rights and social determinants of health. Today, I'm speaking in opposition to SB 709. Criminalizing mask wearing will not protect the safety of any marginalized group. It will create more suspicion of people who wear masks for any reason and make our communities less universally accessible. Discrimination is not a hypothetical here. Years before the pandemic, I faced workplace disability discrimination on the basis of wearing a KN95 equivalent mask. I clocked into work, and right away, my employer confronted me, stating that my mask was intimidating and scary, that I wasn't fit to do my job duties that I excelled at because of what I wore. I was sent to the back room and lost potential wages. I no longer felt safe at work. As a public health professional, I need to call attention to two things. There's many health emergencies and safety crises currently occurring and will occur in the future. Building suspicion around people who mask does affect emergency response and protection regardless of intention. I've already heard cases of profiling and discrimination resulting from mask prohibition bills like this one in other states and academic campuses. These are not isolated cases, and the effects of profiling and criminalization go beyond policing, fines, and incarceration itself. Criminalization and prohibition laws can take away people's basic needs, housing, education access, healthcare, employment, and community. The Unmasked Hate Act will disproportionately harm the most marginalized people in our communities, disabled, Black and brown people, the LGBTQIA community, anyone profiled by police and the criminal legal system. It will not protect us. It will not protect my Jewish community either. As a Jewish Maryland resident, the Unmasked Hate Act isn't going to make people like me or my family any
be safer. All it does is put the most marginalized people at risk of being criminalized for what they wear, disability aid for some, protection for others. I do not stand for anyone being deprived of their rights, autonomy, and privacy in my name. Proponents of the bill arguing about this is about anti-Semitism do not represent me. This is against the values of caring for our communities and making the world a better place. I study health policy changes over time, and I would hate to see the state of Maryland become an early adopter of criminalizing masks in this era and doing mass harm. Thank you.
All right. Thank you all very much for your testimony. Questions from the committee? All right. Thank you all very much. Thank you. Okay. We'll now hear from, did we hear from Allison? Yes, we have heard from Allison, and we heard from Mr. Lombard. Okay. So Rebecca Block and Lawrence Grand Prix, Courtney Bergen, Linda Green, Justin Sindall, excellent. Whoever would like to take the podium first. If I've called you up and there's not enough space, you'll be up next. All right, thank you.
Okay. Hi, my name is Rebecca Block, and I'm a resident of Montgomery County, Maryland. I am a disabled Jewish educator. I am terrified about the rise of anti-Semitism in our society. I dream of a world where my students and my community are safe. I stand in strong opposition of SB 0709, as it will harm the marginalized communities, including Jewish and disabled individuals. This mask ban goes against my Jewish values. A core value of my religion, pikuach nefesh, means that a person must do everything in their power to save the life of another. As Jews, we are taught to care and protect the most vulnerable in our society. If this ban is passed, it will make life more dangerous for medically at-risk individuals to safely exist in public without fear of being harassed or falsely arrested simply for protecting their health and the health of their community. Additionally, this ban would create stigma surrounding wearing a mask. This will discourage individuals from wearing masks even when they have a contagious illness. This will make all of us, including my students, more likely to contract an illness and suffer from post-viral chronic conditions. As someone who became sick as a child and has had to deal with the lifelong repercussions, I would not wish that upon any of our children. This mask ban endangers the marginalized people it purports to support. As a Jew, I am obligated to work towards making the world a better place, a value known as tikkun olam. This ban will not make the world better for any of us. Again, I urge you to oppose the bill. Thank you.
Lawrence Grand Prix, Director of Research for Leaders of a Beautiful Struggle. This bill will chill necessary speech by marginalized populations. I might look to the example of Kwame Ture, SNCC, a civil rights leader, supported Israel as a socialist democracy. But when he changed his mind, he wasn't just seen as wrong, he was seen as physically dangerous. So this is the problem. When you have structural violence from white supremacy or settler colonialism, calling that out as a person will mean that you as a person could be subject to criminal justice backlash. A study by Todd and Neal showed that black faces and black bodies are disproportionately seen as intending violence. How can you have a reasonable intent standard when black bodies are seen as inherently unreasonable and produce unreasonable fear? Let's look at the asymmetry of power of the forces involved here. A nonprofit, nonpartisan center, ACLED, noted in a 2024 report that despite 97% of protests around the Middle East being peaceful, police intervened 5.5 times more at pro-Palestinian protests than pro-Israel protests. So this is the exact sort of black Jewish interracial solidarity that we're trying to protect being criminalized by this bill. A senator from the Ash Center of Harvard said that protest participants have been injured by police or counter-protesters, sometimes severely, about as often as protesters have caused property damage, sometimes as limited as graffiti. I have a student at UCLA, law school. He was at the protest. The problem wasn't the mask. The problem is the police let the counter-protesters do it. It's that asymmetry of power, because he's a law student, but he's going against folks like Bill Ackman, worth $9 billion, who currently is trying to buy Howard Hughes, the property manager of Columbia. He's using his money to challenge pro-Palestinian speech on campus, which is right, but look at that asymmetry of power. You remember masks in Charlottesville? I don't, because they knew they had a regime of conservative philanthropy behind them. And this tool gives them the power to continue to chill speech. These are young folks trying to fight what they think is a genocide. You may not agree with that, but we as the state of Maryland are going to chill that speech. We can't even discuss that. As a debate coach for 15 years, I find that insulting.
Hello, my name is Justin Sindel. I am a senior citizen caretaker in Baltimore City, and I encourage this committee to give an unfavorable vote on SB 709 because SB 709 is an unconstitutional attack on First Amendment rights that will inevitably make those who count on the state for their protection to be even less safe, such as immunocompromised people, neurodivergent people, people with autism, women and non-white people who are more at risk with every police interaction. Make no mistake, SB 709 is going to kill people. This will happen by encouraging more mask bans across the country. This will encourage further harassment of those who continue to wear a respirator to mitigate a virus that's killed somewhere around 2 million Americans since 2020 and disabled millions more. This bill may have so-called exemptions in it, but they just aren't good enough. Further criminalization of masking will inevitably send a message that those who choose to protect their health and the health of others are bad and should be looked at with extra suspicion. This bill will be used against autistic people and other neurodivergent people who may be considered intimidating because of their disability. This bill will be used to further oppress women who have to deal with relentless harassment about unmasking. And this bill will inevitably be used to harass service workers who are trying their best to survive despite the failures of our public health systems. After half a decade of letting a deadly virus ravage the population with minimal help from the federal government, those who've chosen to protect ourselves the whole time should be deified, not treated as potential criminals. Police are not medical professionals, and they should not be in charge of medical decisions. This bill will have a chilling effect on people's ability to safely wear a respirator in public and will do the bidding of the Trump administration and AI-backed digital surveillance companies and further helping them to identify and attack protesters. It's for these reasons and for the millions of COVID-conscious, disabled, and immunocompromised people in this country that I encourage this committee give an unfavorable vote on SB 709. Thank you.
I'm Dr. Linda Green. I'm a physician in Maryland for many years. Public health efforts to encourage masking in the face of serious airborne viruses, including flu and COVID, have been attacked and politicized in the United States. This has led to many cases of illness, including prolonged illnesses like long COVID. By conflating mask wearing with criminality, this bill will further discourage masking. In January, the Maryland Department of Health re-recommended universal masking in all healthcare settings because of the surging rates of respiratory illnesses. Flu rates are at a 25-year high and account for over 1 in 10 emergency room visits. Do not add to this public health problem. In addition, there are laws against assault, harassment, and hate crimes already on the books. Additional penalties for wearing a mask are unnecessary. Jews Against Mask bans in New York documented increased harassment of people who wear masks after the Nassau County bill passed. This bill will further increase racial profiling, which we're familiar with in Prince George's County. Concerns about racism and anti-Semitism are always consideration, but singling out mask wearers for increased surveillance will not solve these problems. In fact, the California Law Review has noted that laws on masking have long been a political football, and in fact, were often an effort to make Southern politicians appear a little less racist while maintaining segregated schools and institutional racism. Residents can face a risk to surveillance by authoritarian regimes and may mask to protect themselves and their families. The International Committee for Human Rights in the Philippines requires masking in protests and meetings, such as the recent campaign for justice for Brandon Lee, which was organized by University of Maryland students. Medical concerns, as well as facial recognition, drone surveillance, and penalties for protesting were all important considerations there. This dangerous bill will do little to stop supposed masked intimidation by protesters, and instead will contribute to the further discrimination of marginalized groups. I strongly urge you to not even consider this bill. Thank you.
Thank you very much, Doctor.
Good afternoon, Chair, members of the committee. My name is Courtney Bergen. I'm an Equal Justice Works Fellow at Disability Rights Maryland. And DRM is here to oppose SB 709 because it would put people with disabilities at increased risks of criminalization and stigmatized masks, which are a critical disability aid. While the proponents of the bill are correct, SB 709 does not all out ban the use of masks. It would require people with disabilities to prove that their need to wear a mask is legitimate if they are deemed to be intimidating or harassing. Importantly, disabled people, especially multiply marginalized disabled people, are already at increased risk of criminalization and police violence, because strangers often misperceive disability-related behavior as harassing or intimidating, even though the individual with a disability may not be aware of this or intend their behavior to be intimidating. Maryland's existing criminal harassment law addresses these concerns by requiring communication of a reasonable warning so that a person is aware that their behavior is being perceived a certain way. But the scheme proposed in SB 709 lacks any warning requirement, making the disability community uniquely vulnerable to being targeted. SB 709 also only provides protections for vulnerable populations as an affirmative defense. Shifting the burden of proof to the defendant to prove their need to mask was not for the purpose of concealing identity, and instead was for the purpose, a legitimate purpose as outlined in the bill. Because of this, people with disabilities, again, will be at increased risk of arrest merely for utilizing a disability-related aid. Historically, fear has been weaponized to justify exclusion of people with disabilities. For example, businesses often use fear to justify exclusion of service animals, despite this being in violation of the ADA. But mere fear of a disability aid, including mask, cannot be used to justify criminalization. Historically ugly laws weaponize similar fears to criminalize disability, excluding disability aids that were deemed unsightly. SB 709 would create a modern-day ugly law. So DRM respectfully urges the committee to oppose SB 709 so that we don't end up with these modern-day ugly laws. Thank you.
Excellent. Thank you very much. Questions from the committee? Senator Sidnor has a question.
Well, before I ask the question, do we have any attorneys that are going to be speaking on any of these panels? Do we know?
So the question was, we do have Dara Johnson here? Yes. Are you an attorney? Yes. All right, so coming up in the next panel. Excellent. And, okay, we have an attorney right here. So we do have an attorney. Yeah, she's an attorney. If it's easier, and look, if it's more convenient for you to, with your service animal to stay where you are, that's just fine as well. Whatever is easiest for you. Thanks.
Thank you very much. I've been listening to you all, and I have a hypothetical for you. You see someone on the street, as you currently are with your mask. Something transpires, and you curse them out. That person then feels intimidated. This law is in effect. From what I'm hearing from you all, from your testimony, law enforcement, let's say they come and they see this, you could be arrested and then would have to go through the process then to prove that your mask was for health reasons and not necessarily to conceal your face it wasn't for the purpose of just concealing your face to intimidate, correct?
Right.
Now, that same scenario, if it happened and you didn't have a mask on your face, law enforcement could they intervene I guess they couldn't intervene and use this law, right?
So they likely couldn't use this law if you weren't wearing a mask, but there is an existing criminal harassment statute, which is, I think, important to remember. Mm-hmm. I think it's criminal law, I want to say 3108, could be off on that. So that statute, like we already have. So the only thing this bill is doing is really just adding masks as an element. So to me, we are criminalizing the mask wearing. Whoops, sorry, not the harassing conduct, which is really what we should be focusing on, is the harassing conduct. And I don't think, someone can correct me, but I don't think the government has a right to know your identity, until you've actually done something harmful, potentially. And so I think we have laws that cover harassment. Why would we need to add masks specifically to criminalize those?
I'll tell you, when Maryland put this masking, wasn't a law, but when we were masking when COVID had initially happened, you had a lot of local governments beginning to say you need to wear a mask. For me as a black man, I was actually thankful that everybody began using them, because initially, until that was said and the general public began doing it, I had a fear of putting the mask on and going in the store for fear of what people were going to think about me. So anyway, thank you for answering my question.
Yeah.
All right, thank you very much. All right, seeing no further questions for this panel, we'll move to the next panel. Is Melissa Wilson, Evelyn Frankel, Dara Johnson, come on up. Katie Overby. Excellent, go ahead. Welcome.
Hi, committee. You can call me Mel. I'm a Maryland resident. I graduated with a 4.0 in cognitive and behavioral neuroscience, and I was on track to attend graduate school for a PhD before promptly developing a disabling form of long COVID in 2022. Thank you for hearing me today. No one should ever have to face harassment when trying to just live their normal life. That is something everyone in this room agrees upon. We all have the right to go about our business peacefully and free from harm. What I want to bring to your attention today is the regular occurrence of harassment happening to individuals who use respirators. I've had people cough on me, quite dramatically, spit at me, yell at me, and follow me around stores. Other people who choose to wear masks have been physically attacked. Jews for Mask Rights has compiled articles of the heightened harassment in Nassau County after the passing of their mask ban bill. I fear this will be our future. I fear my experiences will get worse. I understand that bill sponsors want to reduce harassment in marginalized communities. However, this would be putting those who regularly mask, many of whom come from marginalized communities themselves, in more harm's way. It will lead to the emboldening of harassment, the exact opposite of what this bill aims to achieve. If I'm confronted by someone for wearing a mask or for having a rainbow pin on my backpack, and I speak up to try to defend myself, how do I know I won't be wrongly labeled the intimidator due to the subjective nature of this bill? The representative from ADL just clarified that the mask itself is part of the intimidation. Associating wearing a mask with being intimidating is a dangerous path we need to avoid. This bill would ultimately make public spaces less accessible to those who mask, many of whom are disabled like myself or come from marginalized communities. The repercussions of this bill will greatly hurt those who are speaking today. Passing this bill is not worth it if members of the same groups you strive to protect face greater harassment as a direct result of its passing. Thank you.
Good afternoon. I'm Evelyn Frankel. I'm a Jewish constituent of Senator Smith's. I oppose SB 709. I was raised by my Holocaust refugee parents to believe that never again means never again for anyone. An article in the Washington Jewish Insider is quoted, "The bill's sponsors are billing it as a collaborative effort between the Black and Jewish communities in Maryland, meant as a show of solidarity after the October 7th, 2023 Hamas attacks and the war in Gaza have tested the historic partnership between the two groups." I believe that this bill is weaponizing my history of pain and my longstanding alliances with people of color to disingenuously go after those who protest Israeli government policies. While I appreciate the sentiment of Representative Boafo's statement affirming solidarity between Blacks and Jews, I wonder if he understands the current rift within the Jewish community. Jews are not a monolith. I support Palestinian rights, which puts me in direct conflict ideologically with the Jewish groups who support this bill, such as the ADL. If I go to a demonstration and say, or shout, as a teen of the 60s, I sometimes shout at demonstrations, words that are critical of the Israeli government's policies, especially if wearing a mask, will someone feel that I have the intent to intimidate them? Who decides my intent? Are Jews not allowed to disagree with one another when it comes to issues of morality? Senator Boafo doesn't want to turn his back on Jews, but who has the backs of Palestinians who have borne the brunt of the devastation, whose cities, homes, schools, hospitals, every bit of infrastructure have been reduced to a demolition site, according to the current leader of the Republican Party? As Jewish Americans, we believe that if enacted, this bill would not protect our safety, but instead actually endanger us and our allies who speak out in support of our Palestinian brothers and sisters. While I appreciate Senator Wallstreicher's comparisons and the intimidation of the KKK and their hoods, it is not the Palestinian supportive groups who are stoking anti-Semitism. It is the white supremacists, same as always. Don't drink the Kool-Aid.
Good afternoon, everyone. My name is Dara Johnson, and I am the Interim Policy Counsel for the ACLU of Maryland, here to voice our opposition to SB 709. In addition to being an unwarranted increase in penalties for conduct that is already broadly addressed by existing criminal laws, this bill would open a very wide door to discrimination and privacy violations due to the arbitrary and invasive determinations required to apply its criminal restrictions against wearing a mask or any other concealing article or device. These provisions would severely and disproportionately impact those who choose to cover their body for religious, cultural, medical, or any other reason, and could be used to target protesters and other groups engaged in controversial but not illegal conduct on the pretense that their mere choice to wear a mask somehow coincides with criminal intent. There have already been many examples of law enforcement abusing their power to target communities, such as the many protesters harassed during demonstrations following the killing of Freddie Gray in 2015. This bill would only give the police more discretion to impose their biases against vulnerable individuals, who would then have to go through a harsh criminal process just to defend their choice to wear a mask. Studies have shown that increasing criminal penalties does little to actually deter crime, and this bill would further restrict latitude to tailor outcomes to the subjective circumstances of each case by banning the merger of any resulting convictions with any other related convictions. So while some proponents seem to assert that this is needed to make it easier to identify people, we ask that you all strongly consider whether such a broad restriction on the freedom of expression is worth the authoritarian precedent this would set. With this in mind, the ACLU of Maryland urges an unfavorable report on SB 709.
All right, thank you all very much. Questions from the committee? Senator Sidner. Okay, thank you all very much. Thank you for coming down. Thank you. All right, we'll now hear from, Ms. Fudge, Slight Fudge. Kemye Runsway, Sam Halp. Oh, that's virtual. Okay, never mind. So actually, Ms. Fudge, you're the last one to testify in person. There you go. Welcome.
Thank you. Again, I'm Shelley Cohen-Fudge. I'm with the DC Metro chapter of Jewish Voice for Peace. This bill includes vague language that leaves too much room for misinterpretation. It prioritizes an accuser's perception over a masked individual's actual intent, making fear the key metric of wrongdoing. Intent, if proven at all, is often proven after the fact, meaning innocent people could face arrest or detention before their innocence is clear. A prohibition on wearing masks at peaceful protests will subject protesters to harassment and intimidation and doxing. It will thus chill free speech. The sponsors of this bill have been open about their intent to target speech critical of the state of Israel, describing this bill as a response to protest against Israel's genocide of Palestinians in Gaza. As Jewish Americans, We believe that if this bill is enacted, it would not protect our safety, but instead endanger us by making us vulnerable to harassment, doxing, and legal complications. Anti-Semitism is a type of racism, bigotry, and xenophobia, and as such, it is closely related to and often driven by similar motivations and forces as other forms of racism and bigotry. Enacting an unrelated and dangerous bill does nothing to solve it. Real change requires education and solidarity, not compromising our health and liberties. Thank you.
All right, questions from the committee. Thank you all. And I'll switch to.
Sorry, shouldn't Alexa have some?
Oh, no questions from the committee. All right, we'll now switch over to our panelists who are joining us virtually. And we'll start off with Ms. Runsway.
Good afternoon. My name is Kemia Rinchoe, and I'm a longtime resident of Howard County. I'm here to express my vehement opposition to SB 709. I wear a mask in my daily life to protect myself and those around me against airborne illnesses. Many mask wearers already experience hostility from those who don't mask, and passing this act would further stigmatize mask wearing. There exists in the ranks of police officers nationwide an act now, ask questions later mentality. If a police officer arrests an individual not knowing, for example, that they wear a mask to protect their health, that individual would be forced to remove their mask and would therefore be exposed to airborne illnesses such as RSV, influenza, COVID-19, and more. Regarding the latter, 10 to 30% of so-called mild infections lead to long COVID, which can include but is not limited to developing type 2 diabetes, neurocognitive impairment, and encephalitis. In a situation like this, there would be no redress for that individual having been forced to unmask. Many chronic illnesses and conditions are irreversible and incurable. SB 709 would further stigmatize mask wearing at a time when A, airborne illnesses are especially rampant, and B, the newly confirmed U.S. Secretary of Health and Human Services has made clear his desire to limit access to and information regarding vaccines and other health protections. On another note, in 2021, the Maryland ACLU reported that out of around 23,000 use of force incidents from 2015 to 2019, 91% were committed against Black residents, despite only about a third of the state population being Black. This act would put Black and otherwise marginalized Marylanders, such as myself, at heightened risk for police violence by establishing pretext for increased encounters with police officers. As a concerned Marylander, I urge you to oppose SB 709. It has no place among Maryland's laws. Thank you.
Thank you very much. Next, we'll hear from Sam Halpert.
Good afternoon, Senators. Thank you. My name is Sam Halpert. I'm a lawyer, a Jewish resident of Wheaton in Senator Wallstreicher's district. This bill is an affront to civil liberties and specifically an attack on the rights of medically vulnerable people. The Unmask Hate Act overregulates conduct that is already prohibited. This bill imposes criminal penalties for masked individuals without the existing harassment statute's requirement that they first ignore a reasonable warning. In other words, should this bill become law, masked individuals could be charged with the same penalties already available to law enforcement for the same conduct, but more easily and with less warning. This bill uses harassment as a pretext. Ultimately, it reduces to a clear animus against people who mask in public. By creating sanctions for people who mask, the law forces individuals into an unconstitutional choice between their right to safeguard their health, a 14th Amendment fundamental liberty interest, and their First Amendment right to assemble. The bill's authors have acknowledged that this bill will negatively affect individuals who wear masks for health reasons by including an affirmative defense for people wearing a mask to limit the spread of airborne illnesses. But affirmative defenses cannot salvage this law. People can only use these defenses to ask a court to remedy the legal consequences of an improper arrest. No court can remedy the medical consequences. A person is stripped of their right to protect their health, they are unmasked, and detained. As the CDC has noted, because of the congregate living arrangements in detention facilities, the risk of COVID transmission is higher in these settings compared with the general population. Many Marylanders will see their rights burdened by this law. I won't recite statistics. You've heard them from many of my co-witnesses today. I will just note that this bill threatens to deter those of us who rely on masks for protection in group settings from exercising our assembly rights. No just law can force Marylanders to trade one fundamental interest, their right to protect their health, against another, their right to assembly. Thank you.
Excellent. All right. Next, we'll hear from Maxwell Gutman. Welcome.
Hi. My name is Maxwell Gutman. I'm Jewish and a member of Rockville's transgender community. Before being disabled by long COVID, I was a public school teacher who had genuinely specialized in critical race theory for the last 9 years before it became a buzzword. This bill is being framed as a way to protect both my Jewish and LGBTQ+ communities as well as the Black community, but it will do the opposite. I urge you to oppose SB 709 and any other attempts to restrict the right to wear a mask. A core issue of this bill is the immense systemic disparity behind who gets called intimidating, violent, or criminal due to their appearance. These accusations are already disproportionately made against Black, Indigenous, and other people of color and transgender people. A 2024 ACLU report showed that LGBTQ+ people are significantly more likely to be the subject of police search, detainment, and assault, and at least 68% more likely to be arrested. Black transgender people in particular bear the brunt of those numbers. The fact that law enforcement would get to decide in the moment whether a person has a right to mask for their health or religion, or whether an accusation of intimidation was legitimate, will only result in more racial profiling and more harassment of trans people. No amount of hourly police training workshops will undo centuries of deep-set biases and systemic discrimination behind these statistics. Research has also consistently shown that trans people are at least twice as likely to experience severe effects from COVID, and Black and Latino people are up to 1.5 times as likely. This bill will strongly deter BIPOC and trans people from masking for their health, as Senator Cinder mentioned, for fear of being arrested and fined because someone found them intimidating simply for their appearance, which again is something that already happens all the time. And as these groups mask less often, it will only worsen the gap of how severely we're being affected by COVID and long COVID and put even further strain on our healthcare system, which will even put further strain on those groups that already face issues accessing healthcare. This bill does not unmask hate and harassment, it only encourages more of it, and I urge you to oppose SB 709. Thank you.
Thank you very much, Maxwell. All right, we'll now hear from Isabella McClintock.
Hello, my name is Isabella McClintock, and I'm a Maryland resident. I'm here today to urge you to vote unfavorably on Senate Bill 709. Affirmative defenses for medical mask use are not enough to protect disabled people from the dangerous consequences of this bill. Anti-mask laws will only increase stigma, increasing harassment and discrimination against mask wearers. My partner and I have faced harassment for wearing masks to protect ourselves from COVID-19 on several occasions. One of the scariest interactions took place in a grocery store parking lot this summer. As I approached my vehicle with my partner, a driver rolled down his window, increased their speed in our direction, and shouted, "Take your expletive masks off." This incident took place as the North Carolina legislature discussed legislation that would ban masks in their state. Could our harasser have been emboldened by coverage of that legislation? That I cannot be certain. But I am certain that my household is not alone in the harassment we have faced. After North Carolina's legislation was introduced in May of 2024, a stage 4 breast cancer patient who was wearing a mask in North Carolina was intentionally spat on by someone who said he hoped her cancer would kill her. Studies have shown that Black, Indigenous, and other people of color face higher threats from police when wearing masks. No affirmative defense can protect me from being arrested by a police officer who has decided that I have taken part in intimidation. And no affirmative defense can protect me from irreversible exposure to COVID-19 during said arrest. As a lesbian Afro-Latina resident, I am not made safer by the unmasked hate bill. It would make me a target for more hate. It will make it harder for me to safely exist in public. For these reasons and more, I ask that the committee give an unfavorable report to Senate Bill 709.
All right, thank you very much. We'll now move on to Saqib Ali. Welcome.
Hi, can you guys hear me?
We can.
Terrific, thank you. Thank you, Senator. I'm going to testify as somebody who has been to some of these protests. I've been, during the Black Lives Matter protests and the Palestinian Solidarity protests, many of the participants wear masks. And why do they wear masks? Because they think that they will be doxxed or they will be illegally harassed. And they have a very good reason to think that. The current president of the USA has said he will try and harm and deport people who protest against Israeli genocide. So they have it makes complete sense that they don't want to be subject to like Justice Department investigations and deportations. It can bankrupt people, it can drive them into poverty, even if they didn't do anything wrong. And that's the whole point, I believe, of the sponsors of this legislation, to make it harder and to intimidate people who are protesting in support of Palestinian rights. You know, the ADL who testified in favor of this bill has classified all Palestinian rights protests, all protests in favor of a ceasefire, as anti-Semitic incidents, right? So that shows you what this is really about. And as somebody who has attended many of these solidarity protests at U.S. campuses, I've seen counter-protesters, pro-Israel counter-protesters, right-wing protesters chanting, "Show your face, show your face." Now, why do they want to see our faces? Are we intimidating them? Are we harassing them? No. It's because they believe and they say that just the act of wearing a mask is terroristic. It's not. But that's the kind of idea behind this bill.
So thank you very much, Mr. Ali. All right, we'll now move on to Elise Racine and McFadden. All right. With that, it looks like that'll conclude the hearing for Senate Bill 709, unless there are questions for the panelists joining us virtually. All right, seeing none, thank you all very much. With that, that'll conclude the hearing for Senate Bill 709. We'll now move on to Senate Bill 873. Yeah, come on. So I should have said this before. Just before I start on into this bill hearing, I want to make sure that as a matter of decorum and just fresh dialogue and open dialogue, that obviously I know the last bill was a difficult bill for a lot of folks that came before the committee. The motives for both the House sponsor and the Senate sponsor were, I think, clearly articulated, and I think in some of the testimony that we received from some of the witnesses was misconstrued. And so I just want to make sure that as we have vigorous debate, we definitely, at least engage honestly and understand and assume the best for our sponsors. Obviously, look, whatever you feel about the last bill, I think it's just important to not mischaracterize the intent of both the House and the Senate sponsor, though the bill may be flawed in some people's eyes. I just want to put that on the record as we move forward. So, all right, Senator Smith here to enter into the record Senate Bill 873, which is the criminal law assault in the third degree. And when we were discussing this bill with my chief of staff, my illustrious chief of staff, who is a former public defender, we were kind of going over some of the examples as to why this bill might be necessary. And the example came up of a client where a woman had intervened in an argument between her brother and his partner. And the partner started calling the woman names, and then they all began to argue. And then the woman got frustrated and threw a cup of Kool-Aid at the wall right next to the partner. So the police were called, and the partner said that he feared that he was in danger. So the woman was charged with second-degree assault and faced up to 10 years of imprisonment and a fine of up to $2,500. And with the discussion with other friends, I usually use the example of like throwing a water balloon at someone versus a significant slap in the face to kind of talk about why this bifurcation might be necessary between a second-degree assault and maybe the creation of a third-degree assault. So as everyone here knows, Maryland currently only has assault in the first degree, which is a felony, and assault in the second degree, which is a misdemeanor. An assault in the second degree covers a wide array of behavior, such as the woman throwing her cup, to a more serious crime or assault like a punch in the face. And again, assault in the second degree carries a heavy maximum penalty of up to 10 years of imprisonment or a fine of $2,500, a pretty significant penalty. And there's no distinction between lesser penalties for less severe types of assault, such as non-injurious offensive conduct. So Senate Bill 873 enacts the change of an assault, or enacts the charge and creates the charge of an assault in the third degree that helps make that distinction and that bifurcation between those two types of activity. Creating the third degree, or this third category, will differentiate less harmful incidents from more serious cases that get swept up into that broad swath of a charge for second degree. So what the bill does, the overall intent of the bill is to provide for a lesser charge of a person who would otherwise be charged with second degree assault. So someone who shoves another person, for example, would currently be charged with second degree assault, which is subject to that maximum penalty of 10 years. The bill also defines offensive conduct as non-consensual physical conduct that a reasonable person would find offensive. The bill does not include conduct that results in physical injury, conduct that causes a risk of serious physical injury, a domestically related crime as defined in Section 6-233 of the Criminal Procedure Article, or a sexual crime under Title III of this title. So the bill very simply creates and defines third-degree assault as one who engages in or attempts to engage in or engages in conduct putting one in fear of offensive conduct is guilty of a misdemeanor and an assault in the third degree. It clarifies that unless specifically charged by the state, third-degree assault is not a lesser included offense or charge than another crime. It makes third-degree assault eligible for expungement, and the amendment that should be in your file, I think it's an interlineated copy at this point, clarifies that we're not messing around or changing the current regime for expungement of the second-degree assault or failure to comply with a protective order. So with that, Mr. Chair, I'd ask for the committee's favorable report, and I'll turn it over to my panelist, Mr. Fort.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of this esteemed committee. My name is Christine Dufour, and I come here as president of the Maryland Criminal Defense Attorneys Association. We're an association which has about 450 members who are attorneys across the state in all of our counties. This is a priority bill for our membership, and we wanted to make sure you knew that, because while we understand that under Delegate West's previous legislation about reclassifying crimes, we think it's urgent that we support and this body adopts this bill now. I want to tell you the story about a client of mine when I was a public defender. I'm now in private practice. He is intellectually disabled with the IQ of a 6-year-old, although he's a 30-year-old, 6'2" gentleman. He was in his peer support group where he goes every day, Chesapeake something, and his peer support group workers, one-on-one worker, admonished him not to throw away his lunch because he'll regret it an hour later. Well, my client tossed a near-empty styrofoam clamshell that held part of his lunch, and it hit the peer support worker. The peer support worker went and did a citizen-generated complaint and charged him with second-degree assault. He had to secure an attorney. He didn't quite understand a lot of the proceedings. There was a question about whether or not he was capable to stand trial. I was his attorney. The case went on for many months. I can't even describe the level of stress this man, who really was a 6-year-old intellectually, was under, knowing that he faced the possibility of 10 years in prison. Ultimately, the charges were dismissed, as they should have been, much sooner, but it took many, many months. So this is the type of situation we're talking that Senator Smith is absolutely correct, that second-degree assault covers a wide swath of activities, everything from, beating someone, but it doesn't rise to the level of first-degree assault, right down to spitting on someone. So we urge a favorable report. James Johnson is not going to be here. I believe he is preparing for a murder case, but I believe my colleague, Ms. Rhodes, is on video.
All right, Mrs. Rhodes, welcome.
Good afternoon. Thank you.
Go right ahead. We can hear you.
All right. Thank you. Good afternoon, Chair and members. My name is Laura Kelsey Rhodes. I'm a former president of the Maryland Criminal Defense Attorneys Association, and an active criminal defense attorney and immigration lawyer. I want to highlight that Maryland misdemeanor assault is an incredible outlier across, I'm sorry.
We can still hear her, so keep going.
We can still hear you.
Okay, sorry, I guess.
Can you hear us?
Turn off the, yeah.
If you can hear us, say yes.
Yes, I'm just turning off the other audio I was hearing. I apologize. The reason, you can hear me now, right?
Yes, yes.
I was saying that misdemeanor assault is an outlier, is that the penalty, as we've said, 10 years, is.
Keep going.
Yes.
Don't stop. Just keep going. We'll let you know if we
Right,
can't
all
hear
right.
you. Just keep going.
Okay, thanks. The 10-year maximum is one that is not seen anywhere else in the country, really, for a misdemeanor. It is double the closest things for an assault or other misdemeanor, which there's like 5 years in Pennsylvania and New Jersey. So we have that to begin with. That is the outlier aspect of it to begin with. The second part is that federal law, which is what applies to gun cases and immigration, uses its own definition, not the Maryland definition. So Maryland can say it's a misdemeanor, but no one's going to believe that because it's not the same as as what the federal immigration law definition is, for example. So who is going to be hurt by this in terms of immigration law? Anybody with DACA, for example. DACA means that the person is it's third action childhood arrival, people who came as infants or teenagers brought by their parents, so not of their own volition, and they were minors anyway. And they are left in a limbo, a kind of unbearable limbo in this country. They have no path to citizenship or to getting a green card, no legal path. I guess possibly if they quickly marry somebody when they turn 18, marry a U.S. citizen. But what happens is they're discriminated against in a variety of ways, yet have proved to be an incredibly powerful constituent in this country, very loyal to the U.S. We actually have, I've looked in the statistics, there are at least two DACA recipients who went on to receive Rhodes scholarships. One was at Harvard undergrad, then went to med school there, and the other was a young man from Miami whose mother brought him, I think, from Columbia alone. And he ended up going to Columbia University and is studying migration and other social science issues. So having situations like this where somebody can be summarily dismissed from this country is not really in our interests. I mean, we are benefited by these two and thousands and thousands of others who are in college and doing well and will serve this country. There's no benefit really to us to not help them preserve their DACA. But a DACA person who gets this kind of a conviction could be barred, it's going to be considered a significant misdemeanor and could be barred from that status, could lose their status. The other group, immigration-wise, that's deeply affected is people with temporary protected status, and they have a status, for example, from either civil unrest, extreme civil unrest in their country, or natural catastrophes, mudslides, things like that, like what's happened in Haiti. So I would ask you to consider those groups and rule favorably on this bill. Thank you.
All right, thank you very much. We have some questions. Let's Senator Henson, Senator Love, Senator West, and Senator James in that order, please.
Thank you, Mr. Chairman. Thank you to the sponsor of the bill and the panel. My first question, I am trying to understand what implications this has on our expungement laws. Can you talk me through what alterations are made there?
The bill, as it's originally drafted, did eliminate second-degree assault from being eligible for expungement. As Senator Smith indicated, there's an amendment to reverse that. That was not the intent of either the advocates or the sponsor.
Thank you. I see that amendment. And then second question, it appears, if my understanding is correct, that the bill is taking second-degree assault, harmful or offensive, kind of two different things, and just sequestering the offensive and putting it in for a third-degree assault, since it wouldn't be harmful by nature, because if there's injuries, it wouldn't qualify for a third degree.
And the prosecutor and the police would have the discretion to determine what conduct actually falls within serious risk of serious physical injury, which would exclude it from being eligible for a charge of third-degree assault. I think what we're attempting to do is categorize some serious harm where physical injury resulted versus the push, the shove, the spitting on someone where it's offensive conduct, but it didn't result in injury. And assault, as it now stands, covers all of that. And with, I don't have specific examples of certain judges giving 10 years for spitting on someone. I would say in all candor, my 30 years of practicing, I have not seen that. I've seen people go to DOC for more serious conduct, especially DV conduct, domestic violence related.
You touched on what's at the heart of my question, and it's the discretion. We know that many times there are disparities throughout our criminal legal system where two people might commit the same thing, but if those two people are of different races, of different genders, the punishment that they receive, the charges that they receive might be very different. So my concern is if we leave this overlap where it is the judgment call of, is this a second-degree assault with up to a 10-year criminal penalty, or is this going to be a third-degree assault, that in those instances where bias does come into the equation, that certain folks would get the benefit of the third-degree assault and certain folks would still get charged as a second-degree assault. Is there a way to kind of extricate the overlap so that you remove some of that discretion to have more consistent outcomes?
That I would leave up to the sponsor to determine if there's as a tool to do that. I experience that every day in the courtroom, every day where people are treated differently based on their race, my clients based on their wealth. Unfortunately, I was a public defender for many years in Montgomery County as well as private. I'm now on the Eastern Shore as a public defender and then now in private. So I've seen it throughout my career. I don't know how this body can change that. People are human by nature, and people, some prosecutors treat cases some ways and some treat them differently, and it depends on which county you're in, quite frankly, as well. I would say that having a very well-versed defense attorney who can negotiate and having a third degree would be helpful to advocate, I think, on behalf of whether or not it really should be charged or pursued as a second-degree assault versus a third-degree assault. The other benefit to the third degree is it would keep the case in district court because you don't have a right to ask for a jury trial if the penalty is only 90 days. So what that would arguably do is bring resolution for the alleged victim as well as the defendant much sooner than if a jury trial was demanded to get away from a district court judge, for example, who might give you 8 years if found guilty. There's at least one county on the shore where it's not uncommon for people to ask for jury trials to avoid certain judges. That's the reality of everyday criminal practice.
We've
hope
heard
that
about
answered
that
your-
county. It's pretty notorious at this point. My final point, if the chair would indulge me, I want to make sure that we are not lessening the standard to such a degree that other people who otherwise might not be criminally charged are now swept up into a third-degree assault. So maybe if someone calls an officer and they say, hey, there's just not enough here for a second-degree assault, you go your way, you know, everybody cool off for the night. I want to make sure that with this law, we wouldn't be lowering the bar in such a way that now more people would be charged. I totally get the desire to allow for a different lesser penalty and a lesser charge in circumstances where you'd be charged either way. But my concern is the folks who otherwise wouldn't rise to the bar of second-degree assault.
Right, and I appreciate that. We don't want unintended consequences, which often can happen with legislation. I think, again, it would be the discretion of the officer can't arrest someone unless the misdemeanor was committed in his presence with certain exceptions, domestic violence exceptions, et cetera. But what I'm going to get at is I would hope that an officer and/or a prosecutor would see through the difference. See, does that push really need to be prosecuted or not? Do we put it on the stat docket? Do we drop it? I think the prosecutor, hopefully, again, with good advocacy on the behalf of the defense, would see the facts for what they are. So
I think the only thing missing from your analysis is perhaps the ability for a civilian complaint.
I was just going to add that.
Okay, please, I'd love to hear your perspective.
My biggest concern, and I've testified I testified on a bill across the street to limit the ability for individuals not to access the courthouse, but to limit the ability of a commissioner to put out an arrest warrant in certain circumstances based on citizen-generated complaints. I had a young lady who got in a shoving match with a girl at a bar over a boy, and she was arrested, handcuffed on a citizen-generated complaint, and the charges were dropped 2 months later. So I'm very familiar with that. I walked her through the entire booking process one night. I'm mindful that a citizen can go in. I had a case years ago where someone went in, and I think I've told this body about this case. A young man and his girlfriend were going to a party. She fell out of love with him on the way back. She went to the commissioner and said, "My boyfriend hit me over the head with a hammer." The real facts were, as they were heading to the party, he tossed her his, I call it a Paris Hilton purse, one of those big purses young ladies like to carry. Unbeknownst to him, she had a mini hammer in that purse, and when he tossed the purse, she didn't duck quick enough, and it hit her. She fell back in love by Monday, but at that point, he was already held for 2 nights, held without bond. I got him out of jail. We ultimately got the charges dropped, but he was charged with first-degree assault on a citizen-generated complaint, which turned out not to be at all. He didn't have any criminal intent. So I'm mindful that people abuse the system.
Thank you. Thanks for your testimony. Thank you, Mr. Chair.
Thank you, Mr. Chair. This could either be for you, Christine, or for the chair. Have you had a chance to look at the Maryland Network Against Domestic Violence testimony?
Is that the MCASA?
No.
Okay.
MNADV.
I have looked at some of it. Is it your about their argument that this would hurt domestic violence victims?
Well, I have 2 questions. One is that they talk about domestically related designation happens after conviction at the sentencing stage, and so how that would work here. And then my second question is, abusers don't always need to physically hit somebody to control them. So the throwing something at the wall could be enough to keep her in, quote unquote, her place, to scare her enough. And so if we now have the 3rd-degree assault, have we taken away her protection?
Well, I think that in using Montgomery County as an example, because that's also where I practiced and was at the public defender office, if you have, at the event, the officers are going to be interviewing the people, and if it's a domestic violence, or it could be one, they separate them and interview them separately. So, and they really kind of make the first call about whether they think it's a domestic violence case. Here, it then gets put on a separate docket. So Thursdays and Fridays are for domestic violence cases, and those prosecutors have fewer, not such as a high caseload, so they can handle those with more time. So even though I recall hearing that at the House hearing, but it's officially put on the record after the disposition of the case. Yes, but that doesn't mean it's not treated as a domestic violence case throughout. So I think it would have to be somebody who, where the police officers either completely ignored signals and said it wasn't a big deal, or somebody, or both the people lied and said, no, it's my brother, we're not in a relationship, he's just my next door neighbor, or something like that. So I don't really have, I feel like the domestic violence prosecutors in this state are very good, are very powerful, and I don't see them allowing someone resorting to a 3rd-degree charge if it were really a domestic violence case.
Okay, thank you, Mr. Chair.
Thank you, Mr. Chair. I've had two questions, but I think one was just asked and answered. So let me ask you the second, and that is your written testimony makes reference to the Second Amendment. I wouldn't think off the top of my head that a bill about third-degree assault would deal with Second Amendment issues. So can you describe for us how the Second Amendment is implicated by this legislation?
Absolutely. I'm from the Eastern Shore, also known as the land of pleasant living. We are gun owners. I have a gun safe in my house, or at least I did till yesterday. We're downsizing. And if someone is convicted of second-degree assault, in the criminal code, it's not considered a crime of violence. However, under the public safety code, second-degree assault, albeit a misdemeanor, is considered a crime of violence. So if I'm convicted for pushing someone because they don't want to drop the charge and they go forward, I can lose my gun rights, my ability to hunt indefinitely. And that's also implicated by the federal law as well. But I'll just say, I hope that answers your question, that my husband, if he's convicted of assault, would never be able to hunt again, misdemeanor, second degree. Third degree does not include that component.
Felony or any misdemeanor.
Right. Yeah, yeah. So I hope that answers your question, Senator West.
I know I'm chump change down here, but.
She's up next.
Thank you, Mr. Chairman, and thank you, Mr. Chairman, for bringing the bill. Because of Senator West and that commission that is looking at the entirety of our criminal code, because I'm just looking online, we are so out of an outlier in so many areas of the criminal code, and one of them is distinctly second-degree assault, which is so broad. And it creates a lot of problems, and even the public, and I think our laws should be easily understood by the public. And so you have second-degree assaults that are tremendously dangerous, and I personally think might, I think we're going to look at treating them a little differently, but all the way down to these very minor situations, and then a very sad situation with the developmentally disabled man. So I think that's the intent, isn't it, Mr. Chairman, that you're trying to, sort of tease out and put a spotlight and improve a little bit this wide swath of second-degree assault. So
no,
that's
100% accurate, and I know that Senator West has a commission that's going to study the crime classification task force, and there's no doubt in my mind that had that task force been convened over the summer and will continue its work next interim, that you all will come up with a third degree assault. I mean, I think that puts us more in line, and obviously second degree assault encompasses a broad swath. Yes, that's exactly the intent. To Senator Henson's concerns, look, I think there's got to be a differentiation between two classes of crimes, and obviously, there's always going to be implicit bias and bias interwoven throughout the entire criminal justice system. I think, not to pivot, but I think that's exactly why something like what Charles Sidnor is pushing, to have an understanding of case management and dispositions of cases and charges and amended charges is very important, because you can see some of those threads throughout the entire state, because obviously, and this is more anecdotal than it is factually, but there are differences in between jurisdictions. I think you're going to get different dispositions in Montgomery County, Prince George's County, and Baltimore City than you will in the Shore and maybe Western Maryland. So I think having a greater understanding will help us with that regard. But I think the creation of a third-degree assault statute actually, I think meets the mail. And look, I understand Senator Love's concerns as well, and I think we've all discussed those. So, but yes, to answer your direct question, that's the intent.
Thank you, Mr. Chairman. Yeah, I'm good. Thank you, Mr. Chair. Thank you, Mr. Chairman.
Thank you, Chair. Thank you, Chair.
Chair.
Thank you, Chair.
Chair.
Senator.
Chair.
Please sit down.
Senator. Chair. So thank you for bringing the bill, Mr. Chairman. I want to kind of just hit on a point that I told the senator the other day. I've absolutely enjoyed her candor and dialogue that the senator from the capital city brings to our committee, because it's a really refreshing, very pragmatic approach and well thought out, and really appreciate the way you've handled and asked the questions. I'm going to try to learn some from you. having said that, when she's saying and bringing up these points, I just want to be clear on the one thing, and I think this is what this is trying to do, but maybe I missed something. But the bad thing for law enforcement is you have first-degree assault, serious bodily harm or injury, right? Then you have second-degree assault. But second-degree assault is such a wide swath, and this bill would actually create the opportunity for a lesser charge, so that because the way it's presented now, there is no other option but to charge with the second-degree assault. And depending on who the victim is, they have the right now to even go outside of law enforcement and go to the commissioners. And then law enforcement is responding. It's not even in their discretion. We're putting it in the hands of a commissioner who says, well, this only falls as a second-degree assault, and they can issue charges or a warrant for that. So I love this bill, by the way. I think it's a good bill. I think it's a good, point to jump from, because most states in our country have this type of bill. I don't know how many don't, but I know that most do. The thing about, do you know how many that actually do have it?
I don't, I'm sorry.
Okay.
I'm trying to look up that information.
So the thing about this is that when we're talking about the Second Amendment, when we're talking about things like that, because of how Maryland structured their Second Amendment laws, and it's around the year and a day. So if I remember, that whole discussion years ago was if the penalty was over that it's a misdemeanor 2 years. So it's been up, and so the penalty was a part of the removal of the right or privilege to own a firearm.
Which for some is a very significant collateral consequence.
Very significant, because it could be for something so the simplest way that I know most police officers are taught a lot of things is a second-degree assault is any unwanted touching. It could be that simple.
Yes.
If I walk up to the chairman one day and he doesn't feel like a slap on the back and he feels that's aggressive, he could be like, you just assaulted me. That's a scary, scary thing. Even though in the spirit of the law, the interpretation of it, that was not the intent, which is some of the things you've spoken about, representing. It's by the letter of the law, it's an assault.
Yes.
It's a second-degree assault.
Unwanted, not legally justified touching.
Correct. So that's why I think that this is a really good solution that doesn't enter into the fray for those more things that are much lower on the scale of an assault, but still you want to have an answer. You want to seek justice, but that it's not the intent to create, or intent, I shouldn't say that because intent is an element of the crime, but that there's not an egregious attempt to, there is an attempt to, if you bump them or if you spit on them or you did something like that, but it's not something that is going to cost, potentially medical.
Right. And if I may address, Senator, where I think you're getting at, and I want to address the MCASA concerns, the 3 examples that they outlined.
I saw those.
All 3 examples in my mind would be under conduct that could cause a risk of serious physical injury. If I'm dragging someone across the floor,
Absolutely.
if I'm putting someone
that
up
doesn't
against
match.
the wall.
Those are all secondary assaults. They wouldn't qualify for a third degree.
That's what I wanted to point out.
Yes, and that's what I was.
My analysis.
That's where I was going with that. Is that these are more egregious actions, and just because your body is put together better, you don't. But when it talked about choking, that one I know specifically. I put legislation in years ago that police officers have to ask for the strangulation protocol because of the petechia in the eyes and things that police officers were not seeing, because it creates those things. So that's a whole nother. So those things are out. So
that's what I would argue. Yes. That
and then one last thing I have, if you will, Mr. Chair, and I apologize. I was trying to look at the other one about the domestic related, but the domestic related issues are a non-issue is the way I see it, because they are a separate, all the way together crime within their own, as far as Maryland's created for these assaults.
Right, and I believe the prosecutors treat them differently from day one, whether or not the court ultimately puts it down as
and this is
a domestically related. And oftentimes, I see it all the time, somebody who's going to ask for a police officer to come or is going to do a citizen-generated complaint in a DV context is often going for a protective order.
Correct.
So it's very clear that it's
right,
a DV.
And that was part of the analysis or the addition to the bill that I presented earlier, where we wanted to have that, a person in need of relief, because there's certain variables that are specific to that person.
Exactly.
Those rights, and so, okay, I appreciate it, and I appreciate the bill. Thank you.
Senator, I do have some additional information on your question about the misdemeanor in Maryland.
Okay.
And other states. So this is from the National Council of State Legislators. And it says that 24 states have a maximum penalty for a misdemeanor of 1 year. 8 have 6 months, a couple have 90 days or 9 months. And only 6 have misdemeanors subject to more than 1 year of jail. And the next highest are New Jersey and Pennsylvania, which are 5 years, and the others are between 1 and 5 years. And then there's Maryland.
Can you send that to us for the bill file?
Yes.
Mr. Rhodes?
Do you mind? Thank you.
Yeah. Yep. I was going to say, I can attest to the senator's compliments to the senator from the Capitol City. That did happen. And I think we should, for the citizen complaints issue, that's what I meant to address. Montgomery County, I think, does a great job. That's not a statewide policy, but I think we should look toward what Montgomery County does. John McCarthy, I think, has a second-level review of that with the state's attorneys involved in that. So I think that's a resource-driven solution, but a good thing. Anyway.
Mr. Chairman, members of the committee, my name is William Katzoff. I'm an assistant state's attorney from Anne Arundel County, and I'm here on behalf of the Maryland State's Attorneys Association in opposition to Senate Bill 873. First of all, we think that there's no particular need for the bill. The law that we currently are operating under, if my memory serves me correctly, began sometime in 1996 when we had the assault revision law. Prior to that time, assault and battery were common law crimes subject to common law punishments. The Court of Appeal said at that time that 20 years was not cruel and unusual, which was the limitation if you had a common law penalty. Back in 1996, the law was changed, creating the two levels of assault. First-degree assault, which involved the use of a firearm, or an intent to cause serious physical injury as it's defined in the statute. Basically, it was taken from the old maiming law, trying whether you knock somebody's eye out, whether you took their ear off or something like that. That was maiming. We also, at that time, with regards to felony assaults, we had what we called the Section 12 assaults. The assault with intent to murder, the assault with intent to maim, the assault with intent to rob, the assault with intent to rape. Those were the Section 12 assaults. Those were the felonies. Other assaults, other batteries were misdemeanors. Okay, so in 1996, the law has changed. I don't think that in the 29 years since then, there's been any particular reason or any compelling reason to change the law. Now, with regards to second-degree assault, obviously there's a wide range there as far as the type of conduct that would generate a second-degree assault charge. If it doesn't involve a firearm, if it doesn't cause serious physical injury, then it's a second-degree assault. Now, I screen a lot of cases. I can assure you there are cases involving second-degree assault that are just an eyelash away from first-degree assault. If someone comes to someone with a weapon, places it up against their neck, doesn't do anything other than just place it up against their neck, they're going to get a second-degree assault charge. That's how I look at it.
Okay. Thank you.
And that is deserving at least considering 10 years.
Thank you. You have a question, Senator Folder?
So thank you for coming out and your testimony. I was a little lost. I'm normally in lockstep with the state attorney's office, I'll be honest with you. I'm a little lost, though, where you're coming in that after 29 years and the examples you gave, how you don't support this then. Because you're talking about how someone can, I've seen instances on the first line where someone's taken someone's head and slammed it into concrete. Mm-hmm. And it was a second-degree assault. Because
slammed it in the concrete?
Correct. Because it didn't cause anything. It didn't bleed. It's just they sat there.
It doesn't have to cause it. There has to be an intent to cause serious physical injury.
Correct. But the same person, and the reason I bring it up is because when you see something like that, that's second-degree assault, and then you see somebody that is bandy roostering up and they bump somebody in the chest because they're trying to posture and get their point across, that's also a second-degree assault. Wholly different, though. But the consequences and the penalties are the same. So my question is how does the state's attorney justify those two instances being under the same umbrella of charges?
Well, given the set of facts that you described, the first one, a person's head is being slammed against the concrete. If I was screening that case, they're getting a first-degree assault charge.
Okay, but I'm letting you know that we're talking about their subjective interpretations by state's attorneys that one was a second-degree assault.
I don't know what state's attorney made that determination. If somebody's getting their head slammed against a concrete surface, I'm going to assume that the person that did that intended to cause serious physical injury as is defined in the statute.
So the example you gave was where someone brings a knife out and they put it within put it up to their neck but don't ever actually do anything to them. And you're saying that's a second-degree assault?
I would probably charge second-degree assault because in that situation, the person could probably, if they wanted to, could have done serious damage, but didn't. So I treated it more as a threat, rather than an actual assault with regards to the subsequent injury.
Okay, so in that
if somebody throws a glass at somebody and doesn't hit them, that's a second-degree assault, or it might be a first-degree assault depending upon how hard they throw it. And
well, I guess, and maybe I don't know.
But no one
it
was
seems
injured.
to me that you're making the points that are needed for a third-degree assault because we're showing the variables and how high things can be between first and second, but the very low end of things that are still second-degree assault, spitting on someone. You're telling me that's the same, that should have the same charge available to it, or I'm sorry, same penalties associated with that and someone that brings a knife up and puts it up next to somebody's neck?
Senator, there's no mandatory penalty there. It's a discretionary 10 years, okay? People get anywhere from probation before judgment up to 10 years. I've never seen anyone get 10 years.
Understand that. My point being is you're telling me that between those two types of egregious, one being quite egregious and threatening, that an eyelash hair is, I believe what you said, away from being first-degree assault, and the one where somebody spits on a police officer, and you're telling me those two charges, while maybe not sentenced, but the sentencing guidelines are the same.
Well, if you recall, Senator, prior to the different grades of theft, remember, anything over $300 at one time would be a felony theft.
Yes.
Okay, you get up to 15 years.
That was in 96.
Okay, right. Well, before that, it was before that.
Yeah, before that.
It did include 96, I think. At any rate, it just goes to show you there were a wide range of penalties for a particular crime involving theft over $300.
But that doesn't.
What it just goes to show you, there's a wide range of, the judge is in a position to take into account.
And it's $1,500 now. It's evolved.
Oh, yeah, I know. I said you have different grades of theft now, different grades of misdemeanor, and I think 2 grades of felony theft.
And I liken this to the same thing, that we're looking to add another area that would be important so that we're not putting people in the same group as the person that brings a knife and puts it next to somebody's neck as the person that has a dust-up with their buddy because their Philadelphia Eagles won the Super Bowl and they're a Commanders fan and they hit them.
Well, my attitude, Senator, is this. That's why we have judges, okay, who can take into account the offense as well as the offender and make an appropriate disposition. I've been dealing with that for 47 years now.
And I appreciate that, and I really do. I think it's fair for us to say, though, that if you go in front of a Frederick County judge or a Washington County judge who I've watched them tell somebody, well, I hope you brought your toothbrush today because they didn't want to have counsel, and I go to a downtown Baltimore City or Montgomery County courthouse or some of these other more liberal judges, the penalties associated with the same crimes may not be the same. The disposition applied.
Well, we may have had that same situation years ago in Anne Arundel County, where depending how far south you went, you were either in Anne Arundel County or you were in Culver County, and obviously, in Culver County, judges were a little tougher back there.
I So are you ready to sign on and support?
Absolutely not.
That's what I think I hear. Okay, thank you. I appreciate it.
Thank you. Senator James?
Thank you. I want to bring up what I think is a more policy-oriented problem that we've been trying to address, and I think Senator Smith's bill would really help us. I have been working on a bill with prosecutors to include second-degree assault under a statute that is in every other state and the federal government, that when a defendant intimidates a witness or coerces the witness not to come to court, they can't profit by that, and therefore there are ways to get around hearsay. So if the victim made a statement to the police officer on the night of the event and was recorded, and other protections, that can get into court with a hearing and proper safeguards. But when I've introduced this bill a couple of times, I'm hoping it'll meet with success this year. I've gotten pushback because of the wide swath, again, in second-degree assault. And some people say, well, look, it's not, it can be a very unserious, crime, with not much going on, or something very serious. So, and we're trying to say, look, Maryland has an odd position. It says only felony charges can benefit from this protection, that if a defendant procures the intimidation, keeps the witness out, sorry, let me just back up. In Maryland, only in Maryland, we have limited that protection to felonies. So we are stuck with these non-felonious assaults. So I'm just trying to express to you that without having more little chopped up units that more directly communicate to the public and others what the nature of the crime is, someone who's charged with second-degree assault could have a de minimis situation, as we've heard about, or an extraordinarily serious circumstance. So it seems to me that there's no downside to at least allowing for us to differentiate because of the broad swath of conduct that can come under assault.
Well, we do have a system that differentiates it now, because if you use a firearm or you cause serious physical injury, that's a felonious assault.
I understand that. It's first degree. But when you get beyond that, then second degree, I'm just telling from the prosecutors who have as much experience as you do, they find this a difficult statute, and one that would be better if we broke it up and differentiated between these a very wide swath of behaviors.
Well, there was also a provision in the bill, you may have to have some concerns about that, that says that third degree assault is only available if the state charges it. If we don't charge it, and all we have is first and second degree assault, or just second degree assault.
Well, that may be an issue we can take up.
Well,
I'm not going to try to amend the chairman's bill unless he wants to, but if that's something we can handle, we can handle that.
This bill would solve that. That's the benefit of this bill, is what he just said. That's what I'm saying.
Anyway, thank you for responding to me. I appreciate it.
Okay, thank you. Seeing no other witnesses, that concludes the hearing for 873. Let's move on to SB 925. Senator Smith.
All right, sorry, committee, I don't want to keep everyone too long here. So we've got one last bill and I think only one witness, or maybe a couple of witnesses here. Senator, for the record, Senator Smith here to introduce Senate Bill 925. We passed an iteration of this bill last year. So back in 2016, I think the class of 2014 got to participate in this, but the Justice Reinvestment Initiative. So JRA, as it was known, was an acknowledgement of our failed policies on the war on drugs with relating to mental health, and then also drug dependency. And what JRA did was it sought to address some of those sentencing disparities. It addressed a lot of the mandatory minimums that were on the books. And it sought to help us rethink about how we deal with our sentencing structure with regard to with drugs in Maryland. And the idea behind it was to take that savings that we were going to get from not incarcerating people and treating them and reinvest that money into preventative more proactive treatment measures and proactive measures that would prevent people from getting enmeshed into the criminal justice system because of their substance abuse. And the results have been nothing short of impressive and astounding. JRA, however, did not address revisions to sentences for people who have been convicted under the volume dealer statute and did not provide for sentence modification opportunities for people under the volume dealer statute. So, in part, Senate Bill 925 seeks to address that. And so I'll walk through the mechanics of the bill and cite the pages that of the bill that these particular pieces are attenuated to. Back in 2013, our state legalized medical cannabis. And then since the passage of JRA, that great effort, our state has moved forward to legalize personal use amounts of cannabis for recreational use. And so the first thing that Senate Bill 925 does is to restructure the volume dealer statute for cannabis. And so under the bill, a person found guilty of volume dealing for cannabis can be sentenced up to 10 years and can be fined up to $50,000. And that's on page 5 at lines 13 through 15. The second thing the bill does is to provide for a resentencing opportunity for dealers and kingpins sentenced to the mandatory minimums for cocaine and cannabis. This is something, again, that we had lengthy discussions about during JRA, but never got to. We never addressed it, and that's for a multitude of different reasons. Again, that lays out the process for how the petition has to be filed within a year of the effective date of this bill, which is so September 30th, 2026, as the effective date of this bill would be October 1st, 2025. So that's on page 5, lines 17 through 25. And then next, the bill changes the sentence structure for a person found guilty of being a volume dealer of cannabis. So right now, there's a hefty mandatory minimum on the books for that. It moves it from a mandatory minimum of a 20-year mandatory minimum sentence with a maximum of a 40-year mandatory or a 40-year discretionary sentence and $1 million fine, or both. That's what's on the books right now. And it moves it to a sentence, a maximum of 20 years and or a $100,000 fine, or both. So there's more elasticity and more flexibility for the judge to decide, but it takes off the books that mandatory minimum of 20 years. Did some research onto this portion of the statute. This portion of this mandatory minimum portion of the statute was passed in 1989. We all know what was happening with regard to the war on drugs in 1989. And so that kind of gives you some of the context and flavor for that statute. Fourth, the bill provides for a resentencing opportunity for those sentenced under the prior mandatory minimum regime for cannabis. That's the same portion of the statute that seeks to repeal that mandatory minimum. So you can petition for that resentencing opportunity, and that's on page 7, lines 13 through 21. Now, the second part of the bill deals with the public safety article, and that's possession, selling, transferring, or otherwise disposing of a stolen firearm or obliterating the serial number for that regulated firearm. That is now changed in the bill from a misdemeanor to a felony. That's on page 8. Lines 12 through 17. You might remember that we had quite a lengthy dialogue on that portion of the bill last year. A person who manufactures a handgun for distribution of sale is guilty now of a felony. That's no longer a misdemeanor. That's on page 9, 7 through 13. And then a person who sells or offers to sell a stolen ghost gun is now guilty of a felony, and that's no longer a misdemeanor. That's on page 9, lines 17 through 21, and on page 10, lines 22 through 24. So essentially, this bill recognizes and addresses the failed war on drugs and our posture there. It builds on the success that we had through JRA. It also acknowledges the manner in which our laws have evolved, especially with regard to cannabis. But it also acknowledges the serious nature of gun violence offenses in our state. So I'm now going to turn over the floor to Mr. Harold Morris, who has been an advocate, and I'll cabin this, specifically for the first part of the bill, not for the public safety article bill. I know that you'll speak to that. But has been an advocate, and he's a personal family story that he'll kind of explain why this type of relief is necessary for us to move forward with. And with that, I'll wrap up and conclude that if you look in this portion of the statute, I'd encourage you to read this, the bill, because the mandatory minimums are quite stark for the type of activity that is seeking to address. And the policy movements and I think achievements that we've had over the last several years from 2017 moving forward, especially with regard to how we deal with substance abuse and drugs, this is in line with those efforts. So I just encourage you to read the statute, read the words. And with that, I'll turn it over to Mr. Morris for his testimony, and I'll ask the committee for a favorable committee report, and I'll stand by for questions.
Thank you, Senator Smith and committee and speaker and anyway, I'm Harold J. Morris, father of a nonviolent cannabis prisoner who's on his 6th year in ECI, who is a father of 4, sentenced to 20 years without parole for cannabis only. I'm here to advocate for the removal of mandatory minimum sentencing for cannabis only. Marijuana kingpin statute was designed in the 80s to affect a broad group, not only violent criminals, before cannabis was even legal in any state. Maryland is currently bringing in $1.5 billion per month in cannabis sales, so it's time to update these laws. This bill doesn't allow any illegal market and doesn't open the cell doors to violent criminals. Law enforcement can rest at ease. There's plenty of room for more sentencing, like up to 100 years for cannabis only. If passed, sentencing will still be 20 years maximum, but without the mandatory minimum, meaning parole is an option. Parole is designed to determine whether a defendant is ready to re-enter society. Without parole, it's just punishment and not reform. Mandatory minimum sentence doesn't discriminate, as the judge has no power of sentencing. It doesn't matter if you were a first offense family provider who got caught with 50 pounds of weed without a license, or a career criminal gang leader with guns and a violent history. Nonviolent cannabis mandatory minimum sentencing classifies inmates as violent inmates in the prison system. Nonviolent cannabis prisoners are in the population with dangerous gangs, receiving the same punishment and getting the same diminution credits. 20 days per month for nonviolent criminals, 10 days good time per month for violent criminals, as well as 10 days per month for nonviolent cannabis prisoners. So my son works for the prison. He told me that he had painted bunks that were found cut up and made as shanks in the prison. This is the kind of classification my son is in, with violent people making shanks and murders, drugs, everything, while he didn't do anything but sell pot. I just want to ask that you give a favorable report for Senate Bill 925. Thank you.
Any questions? Seeing none, thank you. Yeah. Senator James.
I want to thank you because we've met, I think, I met you, it might have been the first year you came down and you were eloquent and passionate, and, you know, I want you to, communicate to your son that there are a number of the senators that are really understand the plight he's in and want to be supportive of this bill, and I think we have been supportive. So, yeah, we've gotten this bill out of here in prior years, and hopefully, this will be the year. So I just wanted you to know that I hope you tell him that we are really listening in this chamber, listening in this committee. Mr. Chairman Smith is very committed to this, and a number of us are very supportive of his efforts.
Yeah, I really appreciate that, and I do see that. He's very genuine and helpful, very helpful. And the goal here is to articulate that this bill doesn't open the cell gates for violent criminals. It actually makes it more fair sentencing.
I think we think of it as right balancing.
Yeah, it is.
Anyway, thank you, Mr. Chairman, for letting me make the comment.
Thank you very much, and thank you for your testimony. We have one favorable with amendments. Merritt Williamson.
Good afternoon. My name is Maura Williamson. I'm an assistant state's attorney for Anne Arundel County. I've been a prosecutor for 17 years, and the last 10 years I have focused on felony narcotics cases. I'm testifying today on behalf of the Maryland State's Attorneys Association. We do support SB 925 with amendments. We do support the elements that reclassify the firearm offenses as felonies due to the inherent nature, the problems with ghost guns and such. However, the MSAA is opposed to the relaxing of the penalties associated with the trafficking of large amounts of cannabis. Trafficking a large amount of a controlled dangerous substance is a dangerous business, no matter what the substance is. We are still talking about a valuable commodity. The threshold for cannabis weight count is 50 pounds. To put this in perspective, cannabis on the illegal market has a value of about $1,000 a pound and can be worth up to $1,600 a pound if it's high quality. If sold by the pound, 50 pounds of cannabis can be worth up to $50,000 to $80,000. Broken down more, sold by the ounce, that can be between $120,000 to $160,000. We are not talking about a low-level drug dealer. No one stumbles into 50 pounds of cannabis. This is the amount a drug trafficker would have. With regard to drug kingpin, that is drug organizer, section 9805, plus the weight count. A drug kingpin is someone who is the organizer, supervisor, financier, or manager of a drug conspiracy. This is a charge that only applies to a very particular person at the head of a drug conspiracy. This usually results from a large investigation, such as a wiretap. The particular drug being sold in the course of a conspiracy does not change the fact that a valuable commodity is being sold outside of the legal market, and this carries with it the inherent violence of the drug trade. Thank you.
Thank you very much. Any questions? Okay, thank you very much. That concludes then the hearing on 925, and that should do it.
That's it. Gavel out.
That's it. We can all leave.